Well, that matter 3%.
Mention it on Thursday. That would be better. Thursday. Huh? Mention it Thursday.
I have not seen
Huh?
them. No, Malad, these are 3% incremental benefit. The headmaster discussed the hard.
Okay. When it has been fixed? এই 27th ওই সিমিলার ম্যাটার আছে তারপরে দিয়ে
May I be permitted?
ওকে ফ্রম দিস সাইড দেখে subsistence allowed. You have been placed under suspension. As a 347 upgradation. You give notice to other side. Yes. Now, what is the urgency? That's what can be to challenge. District Land and Administration Officer, so why writ court? Why you are not going to land tribunal? Monthly list of July.
Sir, I am mentioning item number 6. Only matter not today, it will be taken up tomorrow. Please see this. I could not take it.
Okay, not today.
Number 6 tomorrow.
Or any other respondent?
Day after tomorrow. Day after tomorrow.
Okay.
Day after tomorrow.
Okay, at the time of call, Mr. Ghosh, at the time of call.
One side, he is there, other side, I shall inform you immediately. I have taken time, let it be taken up day after tomorrow. I shall inform, and he is one of the side. Day after tomorrow.
26.
Yes.
Okay, 26, come on, 26. Item number 6, sir.
I'm praying for institution of the matter in your lordship on 21st.
25 May, can you give reminder what is the matter? Criminal matter. That is criminal division. Group 9 matter, I stated that how repetition is maintainable. You take instruction. So far my knowledge goes, one criminal division, I asked the question, where in the criminal... It has been restored.
Kindly listen, lordship will come and satisfy your lordship.
3 weeks hence. No specific date. It will appear. It will appear in due course. Don't worry.
My lord,
Yes.
may I permitted to mention
Huh?
item 434 of the monthly list, my lord. This is GST refund matter, my lord. Refund is urgent as due to shortage of working capital, my lord. And here exchange of affidavit already completed, my lord.
What is the urgency?
Refund is urgent, my lord.
Huh?
Refund is urgent due to shortage of working capital, my lord. Did
Working capital
GST
of which company?
my lord, it's
Take instruction, then come.
my lord, this is not a company, it's an individual person. GST refund.
Individual person working capital.
My lord, this is GST refund matter.
Huh?
GST refund matter, my lord.
GST refund matter.
Yes, my lord.
Oh, GST matter.
Yes, my lord.
Oh,
Item 434 of
they
the
have not
monthly list.
refunded.
No, my lord. And here already exchange of affidavit completed, my lord. And this matter only will take two or
Every
2 to
matter
3
will take
minutes,
2
my
minutes.
lord. Kindly upgrade this.
Sometime, yeah. Another, July month.
My lord.
is
Upgradation charge is what?
My lord, I'm praying for upgradation, my lord.
Milord, she is speaking for
It's already
asking for upgradation, Milord. This matter
it's
is
all
already done.
in monthly list, my lord.
Yes,
Yes.
Milord, may I-
Hai.
Upgradation. Milord, insolvency.
Respondents have? The one RTI application may serve your purpose.
Entitled to get from the respondent, Milord. Extremely urgent, Milord. Summons have already been issued. We have already received the summons, Milord. They have now appealed.
So appear. Oh, yeah.
Milord, 287, Milord, it's a hearing matter. Kindly takes up the matter, Milord. It's still pending, it's pending.
So you appear. If you appear, what prejudice you will suffer?
Upgradation charge, upgradation charge. Decided, Milord, it's a very short matter. So only one question of whether the
You want this court to pass an interim order restraining the competent authority to proceed. Insolvency proceedings is going on. So basically, when insolvency proceedings is going on, all other proceedings remain stayed. Basically, it is a fundamental thing. The why each court will interfere at this stage. Huh?
if petitioner succeeds in this writ application, Milord, then they will get the amount which are due with the respondents, Milord. On the pretext that they have blacklisted us, we are not entitled to anything. The matter is pending, Milord. We have
So you have been insolvency proceedings has been initiated against you. So the authority has correctly blacklisted you. You have no capacity or solvency to
solvency, Milord.
to enter into contact now.
Milord, my humble submission is this,
Huh?
that, Milord, my funds are lying with the respondents, Milord. They have not released the funds, Milord. For that we have prayed, Milord. Notice, Milord.
Lordship, may I be permitted to mention a matter? This is a Group 9 matter, Lordship. Lordship, on 11th June, this matter was moved urgently before the coordinate bench of Justice Sen because the Justice was having the urgent determination of a Lordship. On 11th June, an order was passed by His Lordship stating that the BLRO will cause an inspection of a water body where a filling up is going on, and the DAG number was specified 267 and 268. Now we have received a notice from the BLRO. They are causing inspection tomorrow, Your Lordship. But what happens is that they have demarcated a wrong DAG number, that is plot number 40. Now the urgency is, Lordship, if the inspection is carried on tomorrow on a wrong DAG number, the construction that is still now going on,
You point out
Lordship, it hasn't
at the time of inspection, you
Yeah.
appear and point it out.
Lordship, we have issued a letter.
Them that this is wrong plot number.
We did, Your Lordship.
So why you want to restrain the
Not restraining.
BL and NRO to conduct
I'm not
inquiry,
restraining.
which he is going to do as per the direction of the coordinate bench?
Lordship, if I may, the direction was on plot number 267, 268. Now, I have given a letter to that notice saying that you're inspecting a wrong Dag number, and as per the order, it has been mentioned 267, 268.
Point
Lordship,
out,
till today, the BLR has not
you
issued a
mentioned
fresh
this
notice, Your
matter before the authority concerned that this is the plot number, this is the plot number.
Lordship, it has been
I
mentioned.
think BLR will address your grievances.
Lordship, we mentioned it on
Uh,
19th June, but
But
till
what do
date,
you want? One coordinate bench has directed the BLR or
is the urgent
video.
determination of your Lordship.
Who has been directed? BLR or
BLR of South
BLR?
Bengal
A
Parganas.
coordinate bench.
Yes.
So now you want another coordinate bench to
Lordship,
to stay the said order or to sit in appeal over that order?
no, Lordship, Justice Sen was having the urgent determination of your Lordship on that day. Now, because your Lordship was not there, Justice Sen took up urgently this matter and passed the direction.
However, a coordinate bench has passed the order.
Yes, your Lordship.
Either I am to stay that order
Lordship, I'm not asking
or
for
I am to sit in appeal over that order.
Lordship. My only
Which is not permissible, you know very well.
Lordship, that is not the prayer. I was just asking your Lordship that the BLRO be directed to comply in accordance with the order. That is Dag number 267, 268.
You mentioned this matter. It cannot be so today at any point of time it would be taken up.
Kindly keep it to be mentioned tomorrow, your Lordship. The inspection is going to happen tomorrow at 2 p.m. I have the notice. I also have my reply that I have given to BLRO. They are not responding, your Lordship. I've given them that I won't be able to join the inspection until and unless the Dag numbers are corrected, and I have stated that I will seek for the appropriate direction before your Lordship. Then also they have not corrected, and now what happens is that they're going to proceed
The
with
order was passed on your writ petition, in your writ
in
petition.
my writ petition, your Lordship.
Eh?
In my writ petition.
That taking note of this fact, the coordinate bench passed the order.
Coordinate bench specifically directed Dag
You
number
are-
267, 268.
So
And BLRO says the inspection will be carried on Dag number 40. Now the construction is going on a separate Dag.
you place the order of the
It has
court.
been done, your Lordship. I did,
Eh?
but
So
they are not
you
listening.
attend, remain present at the time of inspection, and you point out this thing before the BLRO, let BLRO see.
The only
But
issue-
if you want another coordinate bench to stay the order,
no, not
or
the
to
order,
sit
your
in
Lordship.
appeal over the order, that would
Lordship
not
may
be
just direct the BLRO that to comply with the order and specifically inspect Dag number 267, 268, which is mentioned in the order, nothing else.
okay. If he cause any inspection or in respect of a wrong
Wrong
plot
Dag
of
number,
the
yeah.
order,
Yes,
then that would be not a proper compliance of the order of the
absolutely. Now,
coordinate
now
bench.
what will happen, your Lordship?
So let them do whatever they do.
What happens,
Okay,
your Lordship?
okay. Not
The
you
construction
appear,
will be carried on, your Lordship.
it appear,
That is the only
appear.
process.
Yes.
Malat,
Huh.
regarding Malat 106 item number Malat, it was previously Malat had before your Lordship Malat as a part had Malat, not order but part had Malat, and your Lordship fixed the date 5th of May because of circuit bench other things Malat. That list Malat going on. So your Lordship kindly fix the matter any date Malat, subject to your availability.
Particularly when pattern matter yes.
106.
আচ্ছা এটা পাঠার ম্যাটারে দিয়ে দেবেন পাঠার ম্যাটারে এটা দিয়ে দেবেন পাঠার ম্যাটারে you give the slip
Deeply up.
yes
I want to mention a new content.
no you
My lord permits me to mention for inclusion is an application for addition of two parties, my lord. It's a 2021 writ petition, my lord, wherein the main respondent authority who is a
application for addition of party under the having
additional party,
application
my lord. For inclusion.
With the lordships,
what is the urgency
Pressing urgency, my lord, there are hearing matters, my lord, affidavits,
there is no urgency
not, my lord, pressing urgency.
oh so mention
with the lordship,
mention
matter, my lord, for inclusion in the writ urgency, in spite of the order passed by the Honorable High Court, my lord, the payment was not made by the opposite party. The payment was not made by the opposite party, in spite of the directive
payment
my lord, by the DVC by the opposite party. My lord, the order was passed by my lord Justice I.P. Mukherjee.
so you file contempt
My lord, hence this writ petition, my lord. My lord, kindly, my lord, including the list, my lord, monthly list of July, my lord.
oh if any payment is not made in compliance with the order passed by a coordinate bench, your remedy lies in contempt proceedings.
Kindly
Uh,
include in
Why you are asking the intervention of another coordinate bench? There is an order.
of the notice, everything has done.
You file you think over it again. whether contempt proceedings will be initiated or not.
With the lordship's permission, I want to mention a new content application with respect to an old content application which has been violated. So kindly this is for urgency.
New contempt are passed by this bench.
Yes. Yes, your lordship.
Oh.
So the previous content application petition was violated. Hence
Huh?
the previously filed content application, the order was violated. Hence a new content application has been filed on 16th.
That matter, cooperative matter. Again, contempt proceedings has been dropped. Contempt proceedings has been dropped, making an observation that the order has been complied with. Now, if you feel the order is complied with, then why? Again, the contempt proceedings will be revived.
Not,
Oh, what
not
do you
that
want?
contempt proceeding.
You
This
file
is
fresh
new-
petition.
My lord, this is a separate contempt petition. My lord knows that my lord's direction was that the remaining amount has to be paid within 2 months, and on that point the order will be complied with, and on that point the contempt rule was dropped. But that 2 months period has been over, not a single farthing has been paid, that which amounts to, my lord, violation of that order passed by my lord, pursuant to which contempt petition has been dropped. That's why, my lord, a new contempt application.
Okay, Didi.
I would like to mention a matter for inclusion in
Yeah, Babu, suno. Yes.
Grateful, my lord.
agency that my lord, the petitioner is a CISF personal my lord, who was
Monthly list of July.
Lordship, may I be able to maintain?
You mentioned this matter. I have not accepted.
Please tell me
Lordship.
again.
No, yes.
So this matter upon notice to
You
the
will
other,
go on mentioning one by one.
upon notice to the other side for inclusion.
What is the urgency?
Lordship, the petitioner is in a financially distressed condition. He has prayed for grant of ex gratia payment in lieu of compassionate appointment in terms of the scheme of the Allahabad Bank in which the petitioner's father used to work. This has been pending. The father has died long before 2008, and still they have not granted the ex
Ex
gratia
gratia payment in lieu of compassionate appointment.
appointment in terms of the scheme of Allahabad Bank. Lordship, the matter was
You made a application for ex gratia payment.
yes.
They have not given it.
No.
Okay.
Grateful, Lordship.
My lord, one last thing. My lord, this is a matter, my lord, where the petitioners have prayed for certain benefits. They are working as contractual employees, my lord, under Department of Skill Development Training and Personal Training, under Government of West Bengal, my lord. They prayed for certain benefits. Those benefits were rejected by a reasoned order by the respondent authorities, my lord. Challenging that final order, my lord, the petitioners have preferred a writ petition before this Honorable High Court. The matter is ready for hearing. The matter has been heard.
So what immediate intervention of the court is required?
Immediate intervention, my lord. The
It
matter
can be given retrospectively also.
my
You
lord,
will get certain amount of money according to you.
and my lord, certain
According to you, you will wait for some
there
time.
are a batch of petitions.
Wait for some time. Call the list.
Number 1 for judgment.
And for the Union of India.
Yes. Sorry, Ms. Bhattacharya. Therefore, based on the discussion and reasons set out in the proceedings paragraph, I am of the view that petitioner contention are without merit. I find no infirmity in the decision-making process nor any perversity in the decision of the railway authority to terminate the contract and forfeit the security deposit. Consequently, the petition is dismissed, however, without any order as to the cost.
Grateful to others. Grateful.
Next, Dakut.
I am for the petitioner in this matter.
Matter is ready for hearing, kindly fix a date.
Have
I
the
have
copy.
heard and reply.
I have
Is
given
already
the reply to the
replied.
same also.
Oh,
This is for our approval of appointment of organizer teachers before your lordship.
Kindly fix
Covered
the
by
date,
the
my lord.
judgment of the Supreme Court on
At
the
any day, my lord, at 2 p.m.
DLIT recorded our name. Rastu on the other day made a query for that. Can I করবি না?
কেন হিয়ারিং করে ভাস্কর দা আসবে করবে তো সিনিয়র আছে তো একা একা
আচ্ছা এটা ইয়ে
একে যে করে
ভুলে যাচ্ছে নানার একটা লিখে দিন এফিডেভিট ইন অপোজিশন অন বিহাফ অফ রেসপন্ডেন্ট নাম্বার 3 is taken on record. হ্যাঁ, yes.
my lord, let it be fixed a date, my lord. That will be better. My learned senior friend also agreed with me. Because of that, in this matter, Mr. Bosho is leading me. My lord, today, my lord, it is come under the heading, my lord, to be mentioned. Yesterday, my lord, in the evening, afternoon, my lord, I have got the notice, my lord, that today this will appear. Kindly fix it any day. I need to, because of that, some of the facts it is to be, my lord,
I am ready with
submitted
the
because no, you are ready, but I have to be made ready by
So agree to a date.
any day, my lord, any day.
But let it retain its position, my lord. Otherwise, my lord, if it goes down, it will not be taken
No,
up.
in the
Lordship on the other
prevention,
day took up, wanted to
I,
dispose it
I,
off.
I have
That day they
I
took
have
time.
prayed before your lordship for fixing
There is no
time also.
application can one. What is the can one?
Expeditious here.
So expeditious here.
Oh,
That may be disposed of.
Yes.
তো একটা ফাঁকা ডেট দেখুন তো একটা ফাঁকা আছে দুটোর সময়
2 p.m.
হ্যাঁ হ্যাঁ
2 p.m.
At
2 p.m.
my
দেখুন
lord,
তো একটা কবে ফাঁকা আছে হ্যাঁ 2 p.m. অনেক দূর চলে যাবে জুলাই চলে যাবে নাকি
No, no, June মাসে any day.
না জুন মাসে
my lord, except 30 June,
হ্যাঁ?
my lord, I have some problem. No, no,
হ্যাঁ?
what করে 30?
না না একটা ওই হ্যাঁ আরেকটু এগোন 2 জুলাই হ্যাঁ আর কোথায় 4th জুলাই একটা আছে হ্যাঁ 4th জুলাই সেকেন্ড 2 p.m. ম্যাটার
My lord,
হ্যাঁ
Past
Hello.
2 p.m. we continue.
ফার্স্ট 2 p.m. আর দেখি ফার্স্ট
বেশিক্ষণ টাইম লাগবে না।
হ্যাঁ আছে
It is a very old matter.
Yes, yes,
8 জুলাই
it is not old matter, it's 24.
না না রিট
Oh, আচ্ছা,
ঘটনাটা
matter is
ঘটনার
matter,
প্রবাহ অনেক দিনের।
but this
or 11 জুলাই ফ্রাইডে
First matter,
হ্যাঁ ফার্স্ট 2 p.m. ম্যাটার
11th July,
11 জুলাই
that will better.
to have the learned advocate appearing for the respective parties release the matter for further consideration on 11th July at 2 p.m.
Number 3, I am for the petitioner in this matter.
এই যে
রিপোর্ট কোর্টে ফাইল করুক।
I am on this date.
Why under the heading to be mentioned now?
It's a, my lord, it's a, my lord, my respect to submission, it's a, my lord, stage of motion, because by an order dated, my lord, 10th February 2025, the honorable court was pleased to direct me to file one report. Accordingly, I have affirmed report. My lord, there is no direction for affidavit in opposition or reply. It's the motion stage. my
The
lord.
report itself
No,
conclusive.
certainly not. I have not taken out the, my lord,
Yes.
each and every allegation.
Education matter.
Education matter is the motion. Totally
Report
motion.
covering the whole issue. Why he has
But
filed a
I know,
report by affidavit?
I have not dealt
Could
with,
have used the video opposition.
certainly not, unless there is a direction. You should
Certainly
have
not.
approached before the
Certainly
court
not.
also.
You are in the
There is
report.
a direction for filing report.
Report means
Why should I file, my lord, affidavit in opposition?
there are the directions for
Unless
filing
this writ is
affidavit.
being-
Kindly hold for a minute. 20th of March 2024, direction for affidavit in opposition to be filed.
Huh?
There is the order. 20th of March 24.
Oh. 28th of March.
2024.
No, 15th March 2024 is the order.
The copy of the order. Lordship can look at my order.
এই দেখুন তো
10th of February 2025.
ও জ্যোতি, এটাই কই।
Last order, 10th of February. 10th of February, last order.
No, only 2 order was passed.
Yes.
One on 15th April 2024
Yes.
and another is
Yes.
10th
Sorry,
March.
10th February.
I stand corrected.
Yes.
I stand corrected.
So matter stand released due to want of my determination.
Want? Lordship has a determination.
No.
The hearing determination, my lord.
Motion, education matter, I have no determination.
Motion, no determination.
Motion, education matter, I have no determination.
Unless there is a direction for affidavit in opposition, I
Release it,
will use-
release it, release it.
কি বললাম? Stand released due to want of my determination.
Madam, for the state.
এরা সব to be mentioned এনে দিচ্ছে কেন?
Madam, filing my
matter-
affidavit in opposition.
Why under the heading to be mentioned?
Yes, because the matter was directed to be appeared in the month of April with a direction upon them to file an
Madam,
affidavit.
Filing my affidavit.
But now my landlord.
You are on behalf of respondent number
Madam, 1 and 3.
1 and 3, yes. Have you served the copy?
Madam, I'm serving the copy.
Here and now. So
My
file reply.
My lord, one more submission regarding respondent number 1, my lord. My lord, I have repeatedly contacted them, but no response from them. And some numbers of them are not viable also, my lord.
Well, as the petitioner.
From respondent number 3, we have no objection, my lord. Nothing to be clarified by
Who is respondent number
my lord,
1?
PPG.
Huh?
Respondent number 1 is the director of.
দেখে বলো
No.
সেক্রেটারি হবে সেক্রেটারি রেসপন্ডেন্ট নাম্বার 1 সবসময় সেক্রেটারি হবে বুঝলে ডিপার্টমেন্ট
My lord, the Cultural Affairs Department, Government of West Bengal.
Respondent number 1, Secretary Information and Culture Affairs Department. So who is appearing for the state in this matter?
My lord, I am for the state.
State.
My lord.
So you are representing the.
My lord, but I have repeatedly tried to contact them.
It is an internal problem. What court will do?
No, on
It is your internal problem whether you are getting a proper instruction from the office or from the official you are representing.
well, in
What court?
regards to respondent number 3, I have filed my opposition, my lord.
Okay, what can be done? Acha, affidavit in opposition filed on behalf of respondent number 2. 3 is taken
The writ petition regarding for the GST matter, Lordship, and I am challenging this.
We mentioned. Heading to be mentioned.
Yes, Lordship, the matter is under the heading of for hearing. Yes, Lordship, I have mentioned this matter, Lordship. So, Lordship, I am praying for that. I have challenged the suspensions later, Lordship, in earlier.
Suspension letter.
Yes, registration suspension letter.
Yes.
Lordship, that's challenge before the Honorable Justice Nijamuddin, Lordship. So, Lordship, upon the hearing of this writ petition, Lordship, the Honorable Justice says that there is a 1 year 7 month delay, Lordship. So that's the reason the writ petition was dismissed. Thereafter, I'm challenging the said order, Lordship, before the Honorable Chief Justice, Lordship. Honorable Chief Justice says that the writ petition was restrained and the order was set aside and remanded back to the whole grievances to the adjudicating authority. After considering the adjudicating authority, hearing the concluded and the final order was issued. And the final order has been challenged in this writ petition, Lordship.
There is appeal.
In the asked well, Lordship.
So
Yes,
why?
Lordship, but I have challenging.
Order of the adjudicating authority
Yes,
is
Lordship.
appealable.
Yes, Lordship.
So why you did not?
This
To the adjudicating authority.
one is that.
Jurisdiction of adjudicating.
Yes, Lordship. Another thing is that in the earlier writ petition, I have challenging the delegation of power as well.
When a division bench, you consider when a division bench has remanded the matter,
If he has raised that point, not decided, it's a res judicata. then.
and you are asking a single bench to sit in appeal over that order.
Lordship, in this matter, I have asked my client and informed him that they want to file the one review application before the Honorable Chief Justice, Lordship.
So you know,
Yes.
whatever, if you want to file review application, you file, but the order has been acted upon. Order was passed according to you by the division bench. The Honorable Division Bench remanded the matter to the adjudicating authority. Adjudicating authority, rightly or wrongly, passed an order. That order is appealable.
Yes.
You, without preferring that appeal, you have filed a fresh writ petition.
No, Lordship, in this.
Now you
I have
consider what is the scope of interference of this in this matter before a single bench. You consider.
Lordship, in this matter, Mr. Shivaji Kumar Das, he is
Yes.
hearing. Lordship,
And then you will say that
kindly-
court is
kindly
that
pending
court
this
has
matter
not given me an order.
in the monthly list of August, Lordship. In the meantime,
You prefer the appeal and withdraw the writ
obviously,
petition.
Lordship, kindly.
If any observation is made in that order, that may go against you.
Yes, Lordship.
You consider.
Kindly, Lordship, pending the matter in the monthly list of August, Lordship.
Then why you are pending?
Kindly, Lordship.
It would be, you will say, look how many matters are pending in the High Court. All our judges are taking their salary without doing any job.
In that time, Lordship, after filing the review application, in that time, I withdrew this matter.
No,
Lordship, pending. No,
you withdraw whether you withdraw or I shall
it's not, Lordship. Because
pass the order.
I have not properly instructed from my senior Lordship. So he is engaged in code number 34. So if Lordship kindly pending this matter and
So tomorrow, come tomorrow.
kindly,
Come
Lordship,
tomorrow.
No, kindly Lordship pending. In the meantime, review was filed. Thereafter, I am withdrew this.
Court will not allow you to take advantage of keeping this matter pending in this court. There is an appeal, you go, prepare an appeal. Now, if you want to review this order according to your perception that review will be still maintainable when the order has been acted upon, you may file review application before the Honorable Division Bench.
But Lordship,
You may, and there is an appeal.
Earlier writ petition, I have challenging the delegation of power. That was not considered by the Honorable Division Bench, Lordship. So thereafter, I have
He
challenged
also have
this
then
writ petition not
preferred
only for the
SLP.
But Honorable Division Bench has not considered
Yes,
that
there is
And
no
he's
point
inviting
of
my lord to decide that. He's
you are
inviting
saying
my
that
lord-
before the single bench. Will you withdraw? Withdraw the okay, come tomorrow. Yeah, under the having
Lord,
to
one line order, my lord, all helps us. One line order, my lord.
one line order you give. Come tomorrow. Come tomorrow. withdraw and paper appeal. That would be the appropriate here.
No, Lordship.
Give the proper remedy, proper medicine at appropriate time to your client, okay, but to the patient. Otherwise, patient will die. Yes. Yes, next. 7 দেখো তুমি কালকে মেনশন করলে একদম পুরো মাথায় আকাশ ভেঙে পড়বে, হ্যাঁ, আর আজকে নেই। Item number 7, here appearing.
Appearing on behalf of the plaintiff opposite party.
হ্যাঁ,
Item 7, 087.
My lord, item number 6, man.
item number 6, yeah, it was mentioned, it has been fixed on 26 June.
My lord, grateful lordship.
26 June, yes. I pass this order. Yes, item 7 is your matter.
Item number 7. I beg to appear on behalf of the plaintiff opposite party. There was a direction of service upon me. They have served on last Thursday. I would like to use an affidavit, your lordship. Affidavit to their application and one.
Where is the petitioner?
My lord, I'll tell you, Lordship, my lord, this is, my lord, in respect of a property in Howrah, Manglahat, where, my lord, I am, my lord, 50% owner, undivided 50% owner, and the petitioner is the other undivided 50% owner. On the last occasion, my lord, I said, my lord, though I was not served with the civil divisional application, I said, my lord, I'm concurring and, my lord, actually, my lord, supporting, my lord, the petitioner. Your lordship was pleased to pass an order, my lord. Your lordship, my lord, if your lordship kindly considers lordship's order of, my lord, 2nd of April, my lord, 2025.
That has expired on May 30th. And no attempts have been made to get it extended. Today we are on 24th of this month.
Or until further orders is there, my lord. So, my lord, your lordship may kindly, my lord, extend the order of, my lord, your lordship had passed. My lord, I have been, my lord, not served till now. Have we been served? We have not been served till now, but I am not opposing, my lord, this, my lord, petition. Bhajanan Agency Services, private.
Two outsider making the two owner pro forma respondent and file a suit.
Yes.
That matter.
That
Two outsider has no connection or relation with the suit property. Yes, they file. Now got an interim order.
Yes, my lord, interim order.
Even file an application for enforcement of that interim order.
Yes.
It is the fact.
Thereafter, the police said application was allowed and they have come up, the petitioner have assailed it before your lordship and your lordship was.
Petitioner, who is petitioner?
One of the alleged.
One of the two owners.
Yes, one of the.
Go down. This is a very valuable go down in Mangala.
Oh.
Lordship will kindly consider lordship's, my lord, judgment. My lord, at page.
Today's petitioner has not come.
Today, my lord, somehow, my lord, the petitioner is not appearing.
Their instance because we have not mentioned.
Your lordship, my lord, kindly sees your lordship.
Interim order is also not enforced.
He extends it and provides me an opportunity to deal with the allegations.
Who are you?
I am representing the plaintiff, opposite
party.
Party number 1.
You are the outsider.
Yes.
That is their contention, but I will prove that I have documents to that effect as to my rights, how I am enjoying the property. I'll try to satisfy you.
So you have no objection if the interim order is reinstated?
It was a status quo order, let it be extended, and your lordship kindly provides me with an opportunity to use an affidavit to the petition so that I can disclose my sets of documents.
আচ্ছা আপনি আসুন। আচ্ছা petitioner is unrepresented.
এই নামটা রেখে দেবেন।
Mr. Parthaputi Raimal is appearing on behalf of the opposite party. The paper short pass on. Very short pass on. He is on leg on code number, my lord. 446, my lord. On
Who?
Parthaputi Raimal. Short pass on.
Let me start him. Mr. Rai will come and
Yes, my
join.
lord, that is why he prayed, my lord. He's requested me to
Because
pray.
tomorrow is the date fixing the argument in this room. Lord, I've also brought that order because that's the urgency. Let me let
10 minutes pass on, my lord. 10 or 15 minutes pass on.
Okay, Passover, let him come. Yes. Next, pension method. Item number 9.
I'm for the petition. Lord, the petitioners are challenging the action of the state respondent in depriving them from coming under the pension scheme was promulgated for their benefit. My lord, in 19
Yes. They have refused to grant pensionary benefit to you. Why?
Lord, may I just factually narrate it, my lord, very briefly. My lord,
Why?
in 1988,
You are?
Lord, I'm the employees and or my lord, retired employees of Howrah Municipal Corporation.
Yes.
In 1988, my lord, the Howrah Municipal Corporation promulgated DCRB scheme. Lord,
1988.
Lordship, my lord will find that at page 47. My lord, pursuant to that scheme, my lord, the commissioner of the corporation invited applications from the interested employees who want to opt for the want to come under the DCRB scheme. Now, my lord, initially the cutoff was fixed at, my lord, 1st of May 1989. Since, my lord, adequate number of applications were not received, my lord, that cutoff date were time to time extended up to, my lord, 1992. Still, my lord, there was this issue existing that not enough number of applications were received by the pension system. In 2007, my lord, the state government formed an advisory committee. My lord, kindly comes to page 53 and kindly sees what is the observation of the that committee, your lordship. My lord, page 53.
Same matter is pending before the coordinate bench regarding this DCRB scheme, and out of about 80 to 90 corporation staffs have already filed a writ petition before Honorable Justice Amrita Singh. That case, my lord, an order has been passed and contempt is going on. But that in that contempt, let them be a party there. I think that will be better because multifarious proceedings will be then started. Because that issue is being decided by the Honorable coordinate bench. So if they are added there, I think that will be better. I don't know, my lord. Now it is up to your lordship.
I do not know what's the matter
has
about.
already been disposed of.
But in that petition, some steps, contempt application is being going on. In that case, this DCRB scheme is being decided because state is also a party there, and already the personal
Appearance.
special secretary secretary to the UDMA department has been called for rule has been issued against him. The matter is to be taken up in the next 10th or 18th July, I think. I am there. So, my lord, if they are wait for.
So it would be better you wait.
My lord, today.
You wait for some time. You wait for some time.
What was the matter about?
Let's see.
They can take a copy from me always.
My lord, in that
give
event,
a copy.
lordship, in that event, my lord, kindly adjourn this matter, my lord. May I obtain a copy from my learned senior, your lordship, and then come back.
He
your
will
lordship.
give it. So
Because without going
That
through
is
the
being
process.
decided here.
See, he voluntarily has given this information to you, and standing in court, he is saying, I can supply the copy to you,
I'm
and you wait. You wait. Let the matter go out of list,
kindly,
Already rule has been issued.
my
in
lord,
that
kindly,
matter.
kindly do
I
not.
think he will get some positive.
My lord, I completely agree, my lord. May I just go through that order, my lord, and then come back, my lord? Kindly, my lord.
They needed experience. It is the problem.
Kindly do not do this.
You
my
are
lord.
the junior, have good eloquency, but you consider that. Why I am asking him to wait? Contempt proceedings is going on. If they comply with the order, then they have no other state. Yes, they shall have no other alternative but to
Lord, that is what I'm saying,
can
Lord. What has
benefit.
fallen
So
to
you
me,
wait. Order has been passed. Contempt proceedings is going on.
Been submitted, my lord. The pension is going to be disbursed.
Yes. So
Lord,
No, I
may
think
I
nothing
just,
remain. But in any manner, my lord, I will place this before your lordship. So
my lord, kindly keep this matter day after tomorrow, my lord. In the meantime, let me obtain a copy, my lord, and my lord, let me just go through, and then, my lord, kindly passes any order. If my lord wants to make this go out of list, my lord, kindly do this on the next occasion, my lord. Kindly, my lord. In the meantime, may I
you wait. Rule has been issued. You wait.
know what
Let's
is the matter,
see
my lord?
what
Let me
whether.
just see, my lord. I do not know what is
He is saying the
that's not
state is.
covered by that order.
Oh,
State, my lord, I'm praying for some time, my lord. The brief is missing, my lord. I'm praying for some time, my lord.
What similar matter is going on?
her brief is missing, my lord. For that reason,
Let the matter go out of list.
My lord, kindly do
Liberty to mention. Okay, liberty
My
to
lord,
mention.
kindly
You mention
keep
this matter.
but after
You will not understand anything.
my lord, kindly, my lord, kindly, my lord.
and in this matter, opposition
Yeah.
reply will be there.
The problem is that once you have learned to speak, you will go on speaking.
My lord, there's an order.
You have you followed
Lordship,
what seniors have said.
lordship.
Okay, lordship, no. One writ petition has been disposed of by a coordinate bench. Contempt proceedings is going on. That means that order has been passed directing the state or municipality to pay a pension to the similarly situated candidate. Now, contempt proceedings has been initiated due to non-compliance of that order. Okay, rule has been issued. They are saying the state is going to comply the order. Let the state comply the order.
What I'm saying, my lord, whether all they and the petitioner is in that petition and I are similarly situated because they might be of some other post, your lordship. The most of the petitioners. No.
They are engineers.
That is what I'm saying, my lord. The posts are different. It might not cover me, my lord.
But let that matter be, I think, decided. That will be a help also.
No, my
In any
lord.
manner, I leave it to your
But
lordship.
there is an order of 2024 for exchange of affidavit of Honorable Justice Chanda, your lordship, my lord, will find it and my lord.
Okay, you in that circumstances whether there will be.
My lord,
that means the engineer as a staff of the corporation is also seeking benefit under DCBRP scheme introduced by the corporation. He also, maybe another staff, he is clerk. He also seeking benefit under the same scheme.
My lord,
Better is that, let the order come out, and I think it will be better for everyone.
My lord,
For her also.
factually, it might be
If she
different,
wants
my
that
lord.
opposition reply order will be passed, she will only
My-
pending cases will be pending. And I don't want these persons after retirement should.
So direction was given to file affidavit in opposition.
State would have to give first because state is the main party here.
In 2024, my lord, the order was given.
So when 2 weeks? Why 3 weeks? For filing affidavit?
My lord, from e-shart to nowadays any my lord, this sort of my lord brief can be downloaded. The petition can be downloaded from e-shart to your lordship. So that will not be a bar, I believe, for my learned senior.
A copy may be also handed over to you. A copy may be also handed over by you also.
I have already given, my lord. I'll give another copy. I'll
Okay.
give another copy.
So you hand over.
this is a, my lord, affidavit of
Every service.
my lord, this is an additional service, my lord, pursuant to the earlier order passed by.
Acha, affidavit of service filed on behalf of the petitioner is taken up for hearing. Acha, Mrs. Das. Mrs. Das within vacancy. Any order, he will download everything.
No, I can give the orders also. I have one with me.
Okay.
Lordship.
As a corporation,
Undocumented
my staffs I want should get the pension.
He is asking the learned advocate appealing for the state to download the interpetition.
Already served, my lord. Since the petition.
আপনি একটা কপি দিয়ে দিন নালে আমি আমার কাছ থেকে কপি নিয়ে নিই আমি জেরক্স করব
Okay, if you can,
I can give her a copy.
Order that.
Order I will my lord. If as it fell from your lordship, I should.
Yes.
I should because they are my staff.
Okay, correct.
My lord, only one prayer, my lord.
Ah,
Kindly fixes a date, your lordship. Otherwise, they will again come up and say, no, my lord.
In my
kindly
court,
extend
4
the-
weeks means 4 weeks. It will appear pension matter. Okay, don't worry.
Lord.
Charge of the January. Yes, next.
আপনি আমাদের নাম্বারটা নিয়ে নিন আপনি একটা কপি নিয়ে নেবেন মাস্ট
Then for the petitioner, my lord. But this is the case. Petitioners, I have filed an application because of subsequently, my lord, the PPO was issued and overdrawal amount 13,15,000 has been deducted. Lordship knows, my lord, there is a, my lord, settled judgment that after retirement, no excess payment can be recovered by the authority. Here, my lord, the case is the petitioner was appointed for the post of assistant teacher in the year 2011. Admittedly, when the petitioner was appointed, he was not possessed the, my lord, B.Ed degree. But the law says you have to train within 5 years from the date of appointment. If you have not possessed within 5 years from the date of appointment of the, my lord, B.Ed degree, then after 5 years, your increment should be stopped, yearly increment. My lord, admittedly, I could not, my lord, possess B.Ed degree within 5 years. After 5 years, my yearly incremental benefit was stopped. Then, my lord, 2009 notification, government says that after continuous of 10 years service, you have been treated as a trained teacher. Then after 10 years, which, my lord, 5 years was increment was suspended, that to be resumed. Admittedly, I could not, my lord, possess 5 years, and, my lord, I continued, my lord, service after 10 years by virtue of notification of 2009. My increment, my lord, started in the year 2012, and I have retired 2024. After retirement, the authority says, no, you could not possess the 5 years within 5 years, that the overdrawal amount has been given. The initially, without giving any notice, without giving, my lord, any, my lord, hearing, my lord, they says 1,41,000 it is overdrawal. My lord, they says you have to pay 1,41,000, then your, my lord, pension paper should be proceeded. Otherwise, we could not, my lord, proceed. My lord, I moved a writ petition. The Honorable Court has directed to, my lord, the interim order to pay admissible amount and, my lord, direction for filing affidavit. My lord, despite that, affidavit has not been filed. With that adjustment, now by final, after, my lord, the interim order, my lord, they did not, my lord, complied with. I filed in, my lord, contempt application.
Yes.
In the contempt application, they have, my lord, issued a admissible amount deducting 13,15,000. This is, my lord, can application, my lord, I have, my lord, given a, my lord, PPO.
13 lakhs.
13 lakhs. My lord, kindly see.
From your provident fund.
From
Or
my
gratuity?
gratuity,
My lord, gratuity, my lord, 8 lakhs. But my lord, 13 lakhs, they have adjusted from my arrear pension. My lord, I have not received any amount, 7 except, my lord, the pension. That is, my lord, started from, my lord, May. Only at that amount. Kindly see, my lord, page 17. Page 17 of my lord, can application, my lord.
এই ক্যান অ্যাপ্লিকেশনটা কোথায়? এটা তো সিপিএম।
Can list it.
It is CPN 6.
But CPN has been disposed of, my lord, because of
Disposed of. এই ক্যান অ্যাপ্লিকেশনটা কি ব্যবহার করবো? হুজুন।
before, my lord, before finding, my lord, no, I have, my lord, tried to give, my lord, he refused that, and he received on 22nd, my lord, May 2021. I have that. Kindly
You are
see,
appealing for the state.
my lord, kindly see.
So why you 13 lakhs you have deducted?
And apart from
that is absurd.
my lord, apart from that, my lord, lordship knows.
But my lord, that is the 8 degree, my lord. That amount, my lord, he has drawn, that should be.
Yes, that's why, my lord, my incremental was stopped. My lord, kindly see the recent judgment of this honorable court relying on Rafiq Masi. Rafiq Masi special bench Supreme Court has that after retirement, no amount can be deducted from the retired employee. My lord, kindly see the judgment of this, my lord, this honorable Supreme Court. My lord, may I hand over, my lord? Kindly see.
First is not applicable in this case because, my lord, that is the group 3 and group 3 staff.
My lord, I believe that, my lord, my landed foot should, my lord, read whole judgment. Kindly see page 17 of this, my lord, my can application. PPO. My lord, kindly right hand side. Bottom, recovery, head, then, my lord, amount. Lordship got it, my lord? 13 lakhs 56,529. My lord, my kindly see my gratuity, my lord, left hand side. Need retiring gratuity. Nil. Then, my lord, kindly see the recovery has been made from, my lord, kindly see next. In case of deduction, gross retiring gratuity, amount to be deducted from pension relief, 5,45,664. But gross retiring gratuity, before that, my lord, 8,10,864. When, my lord, my overdwell amount is, my lord, more than gratuity, then, my lord, the arrear pension has been deducted. So, my lord, after retirement, I have not received any amount, 7 except, my lord, the pension, and pension also deducting every month. Because of they have adjusted 5,44,000. And, my lord, kindly see one interesting case. My lord, kindly see the memo. So, my lord, kindly see the writ petition.
So release that amount. Huh?
And my humble.
What is your stand?
That is the
How we will defend such deduction?
action, my lord, he did not got any, my lord, gate.
Huh?
He did not get any gate degree within 5 years. And he was also
You stopped payment of increment
after 5 years.
after 5 years. You have done correctly. Okay. But after completion of 10 years, he will again, as per the rule, although he have not placed as yet.
Page 23 of the report.
He will get after 10 years again his payment of increment will resume.
That's why, my lord, 5 years will be adjusted. My humble submission. Because he has got, my lord, overdrawn.
Why you have not adjusted it when there was master-servant relationship? After severance of such relationship, why you are deducted?
But
You know, Rafiq Masi and a law old judgment, some
Sambhavu Verma. Then, my lord, Abdul Kader. 2009 Abdul Kader.
That is, my lord.
And most probably he preferred an appeal
Well, appeal against the, my lord, interim order.
Against the, you preferred.
I prefer an appeal against the
Appeal.
interim order because
And you read the judgment. Take me to that. I read application. Have you got the application?
Yes, yes.
You come to page 15.
Yes, 20.
15. 15.
Of the application.
Yes, sir.
Huh? Got it? Third paragraph. Single judge one was conscious about the aforesaid proposition of law and invited respondent authority to disclose their stand, obviously to find out whether the case comes within the ambit of those situations and eventualities which rendered the deduction from the retirement benefit impossible. What is the indication of the Honorable Division Bench?
Then, my lord, if you lordship, the respondents have not disclosed the stand now as single bench has now viewed that person and who had attained superiority is accepted to get the retail benefits and therefore should not be deprived of such legitimate right. Since the despite patterns to excess amount have been paid to the writ petitioner's appellant, the single bench passed the interim order directly the authority to calculate the retail benefits, keeping the said disputed amount to be deducted so that the writ petitioner's appellant may the amount on the amount retail benefits or pension. Not find any inconvenience or legality in the interim order.
That is the
Give the
Yes,
decision.
my lord. My lord, kindly see first, my lord, the Rafiq Masih's case.
And Rafiq Masih case, my lord, that is the group
Then, my lord, the
C and D. Kindly see, my lord, first correct. C and D.
no, my lord. There is a, my lord, kindly see last paragraph.
My
lord,
lord,
my lord, paragraph 12. It is not possible to postulate all situation of hardship which would govern employee on the issue of recovery, where the payment have mistakenly been made to the employer in excess of their retirement, be that as it may. Based on decision referred in the herein above, we may, as a ready reference, summarize the following few situations wherein the recovery by the employee would be impermissible in law. 1. Recovery from employee belongings class 3 and 4, group or group C, group D. Then recovery from retired employee. I am covering Roman 2, or employee who are due to retire within 1 year of the order of recovery. Then 3, recovery from the employee when the excess payment has been made for a period of excess of 5 years, 2002 to 2024, before the order of recovery is issued.
Yes.
So, my lord, this is fully covered in the Supreme Court judgment. Apart from that, my lord, the Honorable Division Bench of this Honorable Court has recently passed, relying on, my lord, this, the
Rafiq Masih. Paragraph?
My lord, paragraph, page 13, lordship, page 13. This is the important, my lord, page 13.
Yes.
So, subsequent judgment are taken into consideration Division Bench. It is the manifest from the aforesaid government order that the eligibility criteria of movement of lecturer into
Okay. You come to the proposition.
Proposition, my lord. Taking into the aforesaid facts,
Taking into the
in the
aforesaid.
stand, we do not find any justification on the part of the appellant for attempting to recovery of excess overdue amount from the retired employee. Such and such in case of within the second.
Okay, you.
Yes, my lord.
Okay. You just show that provision that after 10 years.
Yes, my lord. Kindly page, my lord, 27 of this writ petition.
Or 27 of the writ petition.
This is the notification issued by the government, and my lord, kindly see page 20, my lord, page 25. I'm sorry, my lord, page 25.
Yes.
My lord, bottom.
My
lord, column number D.
Yes.
Untrained secondary school teachers shall be allowed annual increment in revised pay structure on condition that such untrained teacher will have to get themselves trained from the institution recognized by NCT in regular or open or distance education mode within 5 years from the date of appointment. an untrained teacher of the recognized secondary school within 10 years teaching experience in recognized school shall be treated as trained teacher for the purpose of trial of increment only, but not the applying for the post of headmaster. So, my lord, after 5 years, my lord, increment has been stopped. Even after continuous 10-year service, I have been treated as a trained teacher, and my lord, increment has been started. So there is no illegality. This is the my lord, the
Okay. One retired assistant teacher of secondary school.
my lord.
Secondary What happened? Twentieth, 30th January 2025. What order? Such? You are dependent. So you want so that Ratan K is not examined.
Order because at page 29 in the earlier round of
Yes. The 11th portion. Yes. Para 5, yes.
the application for appointment of handwriting expert and the fingerprint expert is dated June 6, 1989. That is the deed by which the printer of the defendants became owner of the property in question by order dated February 9, the petitioner, the learned signature passport and download number district South in title street number and it is submitted and the guarded put to appreciate that the registered deed is 698 of the same. It was his partner stated that the have changed over passage of time as comparison of the same implemented that is the finding of the body.
Yes, finding comes para 12.
Yes, para 12. 11 from 11.
Yes.
Yes. Admittedly, the deed was executed in June 6, 1989. It is registered more than 34 years had passed when the application was filed by the plaintiff. It was filed at the stage of cross-examination of the defendant. There is a presumption as to the correctness of the document under section 90 of the Indian Evidence Act 1872. The plaintiff filed an application for obtaining the specimen signature and API of Proton and paid before the court for taking the same of the expert and scientific opinion after comparison of the same. Proton is still alive. He is the best person who has deposed on such issue. Had Proton been examined and had specifically deposed that the signature of API it was not his, the situation may have been different. A statement in the claim that the Proton has informed the plaintiff had that he had not executed the deed was not enough to reason for the court to obtain the signature of API of Proton and say the same for expert opinion. Proton is neither a party to the proceeding nor a witness to the proceeding. The ground taken by the court that the opinion of the expert would not be conclusive should be corroborated with the other evidence and cannot be a reason to allow such application. Ultimately, without the order was set aside. Now, what is the case of the parties? The case is the original property belongs to Virendranath and Bojendra. Now, Virendranath has two sons, Atul and Ratul.
Ratan and
Atul. Virendranath has two
Atul.
Atul. And Bojendranath was unmarried and issueless.
Bojendranath?
Was unmarried and issueless.
Yes.
He died issueless. Therefore, do not.
So entire property devolved upon Ratan and Atul.
Virendranath and thereafter Ratan.
Ratan and Atul ultimately.
Thereafter, what happened? Ratan will not say this. Ratan will not. He transferred the suit property by a deed dated 6 February 2017. Not Milan Haldar. Milan Haldar is the plaintiff.
Yes.
Now that after we made an entered appearance, I did the statement. The statement case is the Atul and Ratan sold the property for Kartik Chandra Boiddo by way of a registered sale.
Ratan and Atul. Thereafter.
No, this is our case. Our case is Ratan and Atul sold the suit property to Kartik Chandra Boiddo by a sale dated 6th of June 1989.
Yes.
They not Kartik Chandra Boiddo sold the suit property defendant number 2 on 7th May 1997.
Yes.
Now, the suit has been filed.
And who is dependent number 1?
My elder brother.
How he is related with the property? Maheshwara another. So Kartik sell to dependent number 1 and 2. Not only dependent number 1. 1 and 2. Yes.
7th May 1997.
Now Milan is the plaintiff. Suit for declaration,
That deed dated 6th of June.
declaration and permanent injunction.
Declaration and permanent injunction.
So Ratan sold out his share.
Yes.
His share in favor of Milan Haldar.
Now, this for declaration that will dated 6th of June 1989 is not a fraudulent document, fraudulent document, and Milan did not execute such a. As of today, that is the claim. That is the claim case. And therefore, if since June 1989 is not executed, therefore, our deed dated 7th May 1997 has no value. This is their case. They are challenging that. Submission. One
Milan challenged the deed of 89.
Yes.
Kartik. Boiddo.
But also our deed of 7th May.
Whereas in response, dependent number 1 and 2 filed an additional written statement challenging the deed of 72, executed in favor of Milon. You said Ratan executed a deed in the year 72 in favor of Milon.
February 2017.
6 February 17. 17. 2007. 2017. Oh. Yes. Okay, however, now this is the presumption attached to which deed? 89. Whether the Ratan sold out in favor of Ratan and Atul in favor of Kartik or not.
Now, that section 90 of the evidence act, and that was the exact finding rendered by the honorable coordinate bench of your lordship.
What find?
Can you see page 11?
Signature, in how many way the signature can be proved?
I do not know that.
Who is the best person to say that it is, whether it is my signature or not?
Yes, best person has not filed the suit. Ratan has not filed the suit so long.
So what?
Ratan has not filed
To unearth the truth, court has every power. Order 18 rule 12. Court has every power. Come on.
Court has a discretion, exercise this discretion.
Yeah.
Keeping aside everything.
Yes,
Order 16, rule 14.
Paragraph 11 of the coordinate bench judgment has no value at all.
Presumptive value.
What presumptive value?
Yes. That means what my learned friend is suggesting, a 30 years document will automatically prove. Then the presumptive. That is why. That is why I am called for Ratan.
Yes.
Ratan should be adduced evidence.
Then what is the five? How similar this unlegal can be legal? Can you see it is a registered more than 34 years of past and such an application?
Acha. Sorry, Mr. Acha, the patent
Already Ratan adduced
Item number 11 to 19.
Only I paid for the petition.
Yes. Yes.
Yes. May I first give your lordship a brief overview of the matter? Then I take your lordship to the relevant documents and the relevant, my lord, the treaties and the notifications issued by the central government. My lord, the petitioner before lordship imported refined soybean oil from Bangladesh. Now, my lord, by reason of a South Asian Free Trade Agreement, which is an agreement entered into by and between, my lord, the SAARC nations, my lord, certain imports are exempted from the payment of import duty, provided, my lord, the imports fulfill the conditions laid down in the said agreement, in the said treaties, and the consequential notifications issued by the appropriate government. For India, it is the central government. Now, my lord, the petitioner imported 2 consignments of refined soybean oil. I will take your lordship to these documents later, and claimed that these documents satisfy the requirement as provided for in the SAFTA agreement, and therefore no import duty is payable on import of such refined soybean oil so far as those 2 consignments are concerned. But initially the customs authorities seized the consignment on the ground that these consignments do not fulfill the requirement of exemption as provided for in the SAFTA agreement. The order of seizure was challenged before this honorable court in a writ petition. But the said writ petition was disposed of by an order directing, my lord, the petitioner to make an application for provisional release in terms of the provisions contained in the Customs Act. In accordance with the directions so contained in the order passed by this honorable court, the petitioner made an application for provisional release. My lord, the provisional release order was issued or passed by the competent authority, which required the petitioner to furnish bank guarantees to the extent of 43 crores and also, my lord, bond to the extent of 60 crores. My lord, ultimately the consignments were released upon furnishing of bank guarantees. But in the meantime, my lord, so far so as to examine the veracity of the moot issue is that the consignments are being imported from Bangladesh. So, my lord, the certificate of origin has to be issued by the Bangladesh authorities. Now, the Bangladesh authorities issued certificate of origin. The Indian authorities say that these certificates are not adequate or, my lord, compliant with the requirements of the SAFTA agreement. So, the Indian authorities, what they did on a parallel scene, they referred the matter back to Bangladesh authorities. The Bangladesh authorities, by writing, clearly indicated that, look, these certificates are genuine, and so far as the conditions laid down in the SAFTA are concerned, those conditions have been fulfilled so far as these exports from Bangladesh and imports into India are concerned, because it is being exported from Bangladesh. The condition which is required to be fulfilled so far as the petitioner's consignment is concerned at that relevant point of time was, my lord, whether there has been, my lord, there are 4 categories of imports into India which are entitled to some exemption provided for in the SAFTA agreement. A, B, C, D. Now, my lord, the certificate contained a column 8 where, my lord, it was specified this is a B category of import into India or export from Bangladesh in the certificate of origin.
Now, B category, though it was further required in the notification that B category would be satisfied only when there has been a domestic value addition in the exporting state. Well, suppose, my lord, soybean has been imported into Bangladesh. My lord, some kind of processing is undertaken and there is a domestic valuation in Bangladesh to the extent of 30% domestic value addition. Then only it would qualify for exemption when it is further exported to India or any other contracting state. It may be India, it may be Nepal, it may be Afghanistan, it may be Pakistan even. So, my lord, this is the situation. Now, my lord, another ambit which arises for consideration is that indisputably, so far as the SAARC nations are concerned, Afghanistan, Bangladesh, Nepal, that's for sure, belong to the category of least developed countries. The term which is used by the United Nations, is that LDCs. These are LDCs. So far as imports from LDCs are concerned, the extent of value addition stands reduced from 30% domestic value addition to 20% domestic value addition. If those requirements are satisfied, then under no circumstance the importer in India could be denied of a benefit of the exemption as provided for an SAFTA agreement, read together with the tariff notification issued by the central government and also the non-tariff notification, the conditions laid down in the non-tariff notification. Having regard thereto, these are the basic facts. Now, my lord, what happens is that your lordship will find that pursuant to the order of provisional release or order of provisional release, the authorities, as per the instruction of the highest indirect tax authority in India, that is Central Board of Indirect Taxes, which was previously Central Board of Excise and Customs, issued a directive to the adjudicating authority in, my lord, in Calcutta, that you make assessment. Basically, I am not happy with the response from Bangladesh, and, my lord, what was done in the meantime, one first letter was issued from India to Bangladesh. Bangladesh confirmed that this is all okay, nothing is wrong with the consignment. The certificate of origins, which are, my lord, they use the acronym COO, certificate of origin. COOs are in order. My lord, in spite thereof, the Indian authorities write once again to Bangladesh authorities that they wanted further clarification, traveling beyond the scheme of the SAFTA even. And, my lord, they say that, look, you give further clarification. The Bangladesh authorities did not respond to the second letter. Since the Bangladesh authorities did not respond to the second letter, what the Indian authorities did, they issued a show cause notice against the petitioner. Well, we have to, we have to examine the issue. These are, my lord, transactions where, my lord, it has been viewed from the model of G2G model. That is government to government model, contracting state to contracting state model, not, my lord, G2B model, government to business model. Because, my lord, the certificates which are issued in Bangladesh, my lord, the importer in India does not have any control over the issuance of certificates. The importer in India simply places an order or indent from the Bangladesh party, and the Bangladesh party exports the consignment into India, and the importer accordingly imports the consignment and bill of entry is, my lord, issued. That's the procedure which is laid down. So, under no circumstance it can be alleged that the Indian importer is in a position to, my lord, kind of manipulate or, my lord, change or, my lord, alter the nature of certificates. And when the certificates are issued by the Bangladesh authorities, which the Bangladesh, my lord, government authorities confirm at a later stage in response to the query from the Indian authorities, my lord, the question arises that whether a show cause notice can be issued, and in the facts and circumstances of the case, whether the show cause notice is absolutely without jurisdiction having regard to, my lord, the scheme of SAFTA. Again, my lord, the scheme of SAFTA provide, in these kind of, there may be disputes which may arise regarding, my lord, determination of the origin. Determination of the origin. Now, my lord, there is a extensive dispute resolution mechanism provided for in SAFTA, read together with the dispute resolution mechanism provided for in Annexure 4 to SAFTA, read together with, my lord, even the Indian notification issued pursuant to the SAFTA. That is notification number 75. So, my lord, my lord, without exhausting that remedy, I put the question to myself with all humility: was it open to the Indian authorities, I mean the customs authorities or the DRI authorities, that is Directorate of Revenue Intelligence, to, my lord, kind of jumping the gun and issue a show cause notice upon the petitioner without exhausting the dispute resolution mechanism contained in a sovereign treaty? My lord, that's the broad issue, my lord, in this matter. Now, my lord, I one by one, we have also prepared a list of dates for your lordship's kind consideration and perusal. ये दो और others को दो, भास्कर को भी दो और कौशिक को भी दो.
Yes.
My lord, these are the list of dates. But before I take your lordship to the list of dates, may I take your lordship to the scheme of SAFTA, which is essential. Kindly take from page 34 of the writ petition once.
Yes.
Now, my lord, kindly take, this is Annexure 1. Your lordship will find Agreement on South Asian Free Trade Area, that is SAFTA. My lord has got that. But I will not read the agreement in its entirety. I will only read the relevant parts. Because, my lord, your lordship's time is more precious than all of us. And that cannot be wasted. Kindly take, my lord, paragraph 1, which is necessary. Sorry, 34. 34. First annexure. The governments of SAARC, that is South Asian Association for Regional Cooperation, member states comprising the People's Republic of Bangladesh, the Kingdom of Bhutan, the Republic of India, the Republic of Maldives, the Kingdom of Nepal, the Islamic Republic of Pakistan, and the Democratic Socialist Republic of Sri Lanka, hereafter called to as the contracting states. Now, we will kindly take, motivated by the commitment to strengthen the intra-SAARC economic cooperation to maximize the realization of the region's potential for trade and development for the benefit of their people, in a spirit of mutual accommodation with full respect to for the principles of sovereign equality, independence and territorial integrity of all states, noting that the agreement on SAARC preferential trading arrangement, SAFTA, signed in Dhaka on 11th April 1993, provides for adoption of various instruments of trade liberalization on a preferential basis, convinced that the preferential trading arrangements among SAARC member states will act as a stimulus to the strengthening of national and SAARC economic resilience and the development of national economies of the contracting states by expanding investment and production opportunities, trade and foreign exchange earnings, as well as the development of economic and technological cooperation. Then, my lord, this agreement was entered into. This is, my lord, the preamble to the agreement. Now, my lord, kindly take some of the articles of the agreement. I'll take your lordship directly to first. The scheme is like this, my lord. Kindly take. The first Article 3. But it is all to promote, my lord, mutual trade and economic cooperation among the contracting states. And the SAFTA shall be governed. My lord, kindly take Article 3, Sub-Article 2 or Clause 2. Shall be governed in accordance with the following principles. Now, my lord, this will be governed by the framework of the contracting states. Contracting states affirm their existing rights and obligations with respect to each other under Marrakesh Agreement, establishing World Trade Organization and other treaties. Now, my lord, kindly come to Clause E at page 38. shall entail, first D and E, shall involve free movement of goods. But this is a very important, free movement of goods between countries through inter alia elimination of tariffs, para-tariff and non-tariff restrictions on the movement of goods, and any other equivalent measures. But the whole purpose was that removal of tariff barrier so as to facilitate trade and commerce between the contracting states who are parties to SAFTA. Now kindly take E. SAFTA shall entail adoption of trade facilitation and other measures, etc., etc. Then there is a national treatment, Article 5. Then the components is important. F is also important, my lord. This is so important, my lord. I'm rightly pointed out by my junior. The special needs of the least developed contracting states shall be clearly recognized by adopting concrete preferential measures in their favor on a non-reciprocal basis. So, my lord, the contracting states would take care of, my lord, other contracting states who are at that stage of time or at that relevant point of time are categorized as least developed states. My lord, this is to ensure that, my lord, an economic equilibrium is created. This is a measure to ensure that there remains my lord, what should I say, create a level playing field for the least developed nations, because, my lord, they are if and when compared to, my lord, some of the other nations, they are not financially that developed or economically that advanced. Now, my lord, kindly take the components. 6. SAFTA may entirely consist of arrangements relating to tariffs. This is relevant. Para-tariff, non-tariff, and direct trade measures. We are concerned with tariff essentially. Now, the trade liberalization program. Then it comes to, my lord, what are the tariff reduction measures which would be there for the least developed contracting states? Your lordship will find at Article 7, Clause B. Clause A is for non-least developed contracting state, which is, my lord, India, and least developing developed contracting state, which would include Bangladesh, indisputably. And this fact has not been disputed in the affidavit in opposition. My lord, this is how it stands, my lord. Then there is, my lord, kindly take, my lord, D. 7(1)(d). This is again for least developed nations. So, my lord, I am not troubling your lordship with the entirety of this issue. Kindly take. Now, directly come to 10(3). This is for institutional arrangements. My lord, first the contracting states, page 41. The contracting states hereby establish the SAFTA Ministerial Council. My lord, will kindly take Article 10. Because Ministerial Council would have a role, my lord, in resolving the disputes if they arise between the contracting states and their components. The contracting states hereby establish the SAFTA Ministerial Council. The SMC shall be the highest decision-making body of SAFTA and shall be responsible for administration and implementation of this agreement and all decisions and arrangements made within its legal framework. SMC shall consist of ministers of trade and commerce. That's not relevant for this purpose. Kindly take 5. SMC shall be supported by a committee of experts, hereinafter referred to as COE, with one nominee from each contracting state at the level of senior economic official with the expertise in trade matters. Well, this committee of experts shall monitor, review, and facilitate implementation of the provisions of this agreement and undertake any task assigned to it by the SMC. The COE shall submit its report to SMC every 6 months. Now, this is very important. 7. The COE will act as a dispute settlement body under this agreement. Now, my lord, along with this, kindly take, my lord, straight away, come to Article 20 and 20, 19 and 20. Page 46
Yes.
of the writ petition.
Yes.
Consultations. Article 19. Each contracting state shall accord, well, kindly note the language for your lordship's consideration, obviously. Sympathetic consideration to and will afford adequate opportunity for consultations regarding representations made by another contracting state with respect to any matter affecting the operation of this agreement. The committee of experts may, at the request of a contracting state, consult with any contracting state in respect of any matter for which it has not been possible to find a satisfactory solution through consultations under paragraph 1. Now, my lord, Article 20. Dispute settlement mechanism. Any dispute that may arise among the contracting states regarding the interpretation and application of the provisions of this agreement or any instrument adopted within its framework concerning the rights and obligations of the contracting states will be amicably settled among the parties concerned through a process initiated by a request for bilateral consultations. Any contracting state may request consultations in accordance with paragraph 1 of this article with other contracting state in writing stating the reasons for the request, including identification of the measures at issue. All such requests should be notified to the committee of experts through the SARC secretariat with an indication of the legal basis for the complaint. If a request for consultation is made pursuant to this article, the contracting state to which the request is made shall, unless otherwise mutually agreed, reply to the request within 15 days after the date of its receipt and shall enter into consultations in good faith within a period of no more than 30 days after the date of receipt of the request with a view to reaching a mutually satisfactory solutions. If the contracting state does not respond within 15 days after the date of receipt of the request or does not enter into consultations within a period of no more than 30 days or a period otherwise mutually agreed after the date of receipt of the request, then the contracting state that requested the holding of consultations may proceed to request the committee of experts to settle the dispute in accordance with working procedures to be drawn up by the committee. But it is like conciliation and arbitration. The first process is like conciliation between the parties. If the conciliation fails, then you go to the committee of experts established under Article 7 and the issue will be decided by the committee of experts. Consultation shall be confidential without prejudice to the rights of any contracting state in any further proceedings. Along with this, my lord, kindly now take page 101. This is part of Annexure 4. The Annexure 4, it starts at, my lord, page, Annexure 4 to the agreement rather, of the SAFTA agreement. The SAFTA rules starts at page 96. I take your lordship to page 101.
Yes.
Kindly take, my lord, rule 16.
Yes.
Your lordship will find, may I just take your lordship to rule 16 first, then I will, my lord, I will try to summarize in my own humble way. Consultation and cooperation between the contracting states. The contracting states will do their best to cooperate in order to specify origin of inputs in the certificate of origin. The contracting states will take measures necessary to address, to investigate and, where appropriate, to take legal and or administrative action to prevent circumvention to these rules through false declaration concerning country of origin or falsification of original documents. The contracting states will cooperate fully consistent with their domestic laws and procedures in instances of circumvention or alleged circumvention of these rules to address problems arising from circumvention, including facilitation of joint plant visits, inspections and contacts by representatives of contracting states upon request and on a case-by-case basis. If any contracting state believes that the rules of origin are being circumvented, it may request consultation to address the matter or matters concerned with a view to seeking a mutually satisfactory solution. Each state will hold such consultations promptly. So, my lord, if we read, subject to lordship's kind consideration, Rule 16 of SAFTA Rules of Annexure Origin, as contained in Annexure 4 to the agreement, together with, my lord, Article 20 of the main agreement, your lordship will find a comprehensive dispute resolution mechanism has been provided for. First, there may be exchange of correspondences, which may also entail, my lord, site visits. If all those things does not work out, then consultation, that is stage 2. If that also doesn't work out, then we have to take recourse to Article 20 and the matter has to be referred to the committee of experts established under Article 7 of the agreement. Article 10 of the agreement. I'm so sorry. Article 10 of the agreement. So, my lord, it is a 3-tier process. My lord, first tier is the, my lord, exchange of correspondences, maybe physical visits. Second stage is consultation. And third stage is, my lord, this COE or the committee of experts. Well, this is, my lord, perhaps your lordship will try. My lord, when do I come back? When do I come back?
July. আজকে বোধহয় শেষ হবে না whether shall I fix at 2 p.m. and complete on that date both sides?
Lordship, in that case, let my knowledge senior to complete, will take another day and leave the house.
Well, kindly fix it at 12 noon. It will be convenient, my lord. Any day subject. Obviously, my lord, we have to abide by your lordship. And one more, my lord, very unreasonable request I am making.
Yes.
My lord, the unreasonable request is that there is one matter your lordship was kind enough to post at on 30th at 2 p.m. My lord, it is entirely my fault. My lord, I will not be in a position, my lord, because there are multiple issues which are there on that day. Well, I would request your lordship. I have already informed Mr. Shagor Bandopadhyay is appearing for main contesting respondent. We have given, I have spoken to him personally. Well, can this matter, I have brought the order also, be posted on 8th or 9th subject to your lordship's pleasure? 8th or 9th?
8th or 9th,
this is the other matter. 8, 9, 10, 11, whichever date.
12? 12 at 2 p.m. 12 ফাঁকা বলছি
12 is Saturday. না
কবে ফাঁকা বললো 12 Saturday.
12 is Saturday. 12 is Saturday. 12 is Saturday, my lord.
Okay, তাহলে দেখুন না 14 জুলাই কবে 14 July. That matter is 14 July.
14 July, very
14 July 2 p.m.
Yes, and this matter, my lord.
This matter এই কবে দেখুন তো একটা 12 p.m. পড়াবো না। আর জুলাই তো আছে বলছি। So 1st July at 2 p.m. 12 p.m.
1st July at 12 p.m.
I am passing order. First agree to that date.
One second, man. Just one.
Acha, had the learned advocate for the respective party list the matter, place the matter in the list. Acha, for further consideration on no 8 July 8 July হবে না
নিচে লিখে দিয়েছি
হ্যাঁ 15 জুলাই না রেসপেক্টিভ পার্টি বলে দিন আমার কোনো
This one is 14 July, my lord. The other one
14 July, yes. এই matter
is
It's other matter list of this.
I believe, Lord, Lord, I believe there is a matter fixed at 2 p.m. May I have your liberty to mention a matter very urgent? Lord, I believe my learned junior mentioned it in the morning, but he was not able to, Lord, explain things properly. Lord, kindly takes this notice. Pursuant to an order, an inspection has been directed to be carried out by the BLRO. But the BLRO has made a very basic mistake in the plot number. But he is saying if the honorable court, Lord, clarifies it as per the order.
I asked your junior, you point out before the BLRO. Now you want the BLRO to restrain the BLRO from causing any inspection.
No, not at all. Not at all. That's what he has done wrong. My lord, we only want the inspection to be carried out with the correct plot as per the order of court. So, my lord, we again contacted with the BLRO after he mentioned. The BLRO said, I know maybe it may be a mistake. If the honorable court just clarifies that it is that number as per the order, I will carry out there. Not only thing, well, just to be mentioned.
To be mentioned, who is the other side?
But I have already informed in the morning. I will again inform. Tomorrow, let it be to be mentioned.
Tomorrow,
Yes.
to be mentioned. Yes, fixed matter. Call the fixed matter.
Your lordship was used to get the article of file a supplementary evidence. And then the copy final order of April 45 of 2001. This is the copy US strategy. Correct. And prepare the supplementary.
You have missed the chance. What can be done?
Yesterday we have missed bullet. I need to point out that
Okay. Yeah.
the Arasat was supposed to be present. I will inform the
Okay. You are Mr. Roy or Kundu? As Mr. Kundu, Lana Type, requesting the petitioner submit that petition. Okay, not today. ফিক্স ছিল না আজকে ওরা ভেবেছে 2 PM টা চলবে বোধহয় আর ইয়ে করেনি নিন হ্যাঁ একটা ফার্স্ট কল দিয়ে যান আর কি
For the petitioner, Lordship, led by Mr.
25.
Chakraborty, yes, Lordship.
Yes, place the matter.
Lordship, there is a direction for filing the affidavit in reply.
Affidavit in opposition is on record
Yeah.
or still with them. Affidavit in reply, another affidavit respondent number 2, affidavit in opposition on behalf of respondent number 3. But affidavit in opposition on behalf of respondent number 3 and 4 is not on record. He appeared Dipon Kumar Sarkar and 4 Pritish Rai Chaudhary.
Matter was regarding an appointment which was conducted by the College Service Commission, Lordship.
You want a mandamus commanding the respondents to reserve one post?
Yes, Lordship.
Why post will be reserved?
I am not the advocate on record, but for the post of Assistant Professor, Lordship. Assistant Professor in the subject of English. He made some allegations that we have done some obscenity through social media against their belief, but which is not relevant and against the Article 19, Lordship. Party थोड़ा चावल रखिए। I'm appearing with the college service commission led by Mr. Subram's Panda.
Led by Mr.
He is coming. Mr. Subram's Panda. Let here. My lord, college is made answering responding in this matter. কলেজ তারাই কি আপনি তোমার কলেজে না না আমরা তো কমিশন
Lord, I am appealing on behalf of College Service.
Fact
Is, my lord, in terms of 2020 selection process for the post of assistant professor conducted by West Bengal College Service Commission, the petitioner was successful and empaneled candidate, and my lord, we have recommended to the college mission as per requisition made by the college service, my lord, concert college, and despite recommendation, college authority has refused to, my lord, issue the appointment letter on the score that some, my lord, remarkable speech was, my lord, given by the petitioner. This is the only ground.
But this is not remarkable.
But that is their allegation.
This has been termed as a disparaging remark, which is tantamount to obscenity. Then, my lord, let me allow my lord to place my case.
The college.
Lordship?
So the college is the appropriate authority to answer.
For the last occasion,
They have filed their affidavit, my lord.
College means respondent number.
The Ramakrishna Mission.
Let me allow to my place it.
Respondent number 3 and 4.
Let me allow to place it. They will come, my lord. Yesterday also they were attending this court, my lord. Very vigilant. Let me allow to my place it, and my lord, they will come, my lord.
They
will come.
This difficulty is, my lord, despite recommendation, but the petitioner is, my lord, blaming me to give another recommendation. but the one selection, one recommendation can be made. It can be understood is there is no vacancy, but the requisition has been made wrongly, then I can understand, but I can make arrangement. But difficulty is if the every day the college authority has refused to give appointment, then why they have made a requisition for filling up this post?
Only
We
stumbling
have
block.
conducted based on the notification issued by the state government, and they have made a requisition for filling up this post. Based on that, we have recommended from the impanel candidate.
My lord, the college authority at the very outset very categorically informed the College Service Commission they are not going to permit any women candidate to be their professor. This was the only bar, and this has been adhered to by the College Service Commission, and they have selected a person who is at least he is a male person, and my lord, having the requisite qualification for the purpose of my lord teaching them, and my lord, he is an associate professor under Delhi University. That being the situation, I am placing my lord certain document and testimonial.
Let them come. If they do not come, there will be wastage of judicial hour. What?
No, my lord, my humble submission, my lord,
For
we are suffering from 2023. And my lord, the kindly see, the person who is a petitioner before this honorable court is associate professor. He has purchased a flat. After this selection, my lord, he has sold it out. Now in a rented portion, number of books are there that was required to be shifted from my lord Delhi to Kolkata. And the gentleman used to stay there without having his library, which is a punishment for an academic person. My lord, supposing my lord a lawyer is doing work without his SCC online or my lord the books, but it is possible for him, and he is doing work in Delhi, but the books are in Calcutta. Keeping in the mind, today or tomorrow, he will come, my lord. He will come. Then I am placing it, my lord. Kindly.
You are for the college authority?
Yes.
But I have filed my reply. Let me allow my lord to place it. But I have.
I appear for the secretary of the Ramakrishna Mission, Narendrapur. But on the last occasion, Lordship had heard the matter, where there was a recommendation by the College Service Commission. The recommendation was regrettably not accepted by the college authorities. Lordship had posed a query because I had raised an argument of maintainability, saying that there cannot be a writ petition for issuance of a mandamus to enforce a recommendation of the College Service Commission, and that there are authorities of this honorable court to that effect. Lordship had fixed the matter thereafter to listen to this limited point of maintainability. Now, my lord, if my lord is pleased to take it up, Lordship, I'll place the judgments and I'll satisfy Lordship that there's no...
Place the judgment.
Lordship. Lordship will give me 10 seconds to catch my breath.
So no writ lies?
No writ
to enforce the to recommend.
Lordship.
So the college authority is at liberty. They can
Lordship.
Own will and volition,
accept the recommendation. They can so
Lordship,
you will be debarred from sending any recognition requisition to the college to service.
Now, my lord, there are two things here.
No, as per your requisition, the college service authority cannot play.
My lord, this is an.
They will make you make requisition. Based on that requisition, they will act. Thereafter, you will throw it. That it is a play. Your game is not my liking. Why they have made a requisition?
My lord will kindly appreciate. There are two things here. One is.
And you have filed jointly, repeated in opposition jointly. 3 and 4?
3 and because 3 is the.
But here two different advocates are representing them.
Malad, I'm the one making the submission. So therefore, Lordship, as a matter, we filed the joint affidavit because the stand is the same. One is the principal of the college, one is the secretary of the center. Now, Lordship, there are two things here. To, if I may try and satisfy my lord. The College Service Commission gives a recommendation. Now, that is a recommendation. Now, Lordship may say that if we can throw it away at will, then what is the point? Lordship, the answer to that most humbly is, just as a recommendation is not binding, when a college authority says that we are unable to accept the recommendation, there must be reasons for it. If no reasons are given for it, then there is a case to be
Why
made out.
you are giving such ye?
Well, this is the settled law of our honorable court. May I prove the judgment?
That this law
What
has
is the
been
reason over here in their
You
evidence? in
cannot
opposition?
Well, reason
according
as
to your own way.
Well, I have
Lordship, and one more point.
Slow the
I am
judgment
placing,
fast.
Lordship, my learned friend is speaking.
You are not prepared at all.
No, no, I am
All
fully
are
ready.
Playing.
My-
Court is also playing, sitting here.
That's 2 years, my lord. My pension agony going on.
Apart from College Service Commission, there is no avenue to appoint the assistant teacher.
Assistant professor.
There is no avenue.
So henceforth, don't act on the basis of requisition.
That will be
Huh?
They are the
next time we shall take care about that. Their requisition.
My lord, may I place?
Well, they are also playing with the fate of the student, their future also.
Yes.
May I place, Lordship, 2016?
Yes, come to 11th portion that
Lordship, kindly
that
comes
a
to
college
page.
can refuse to accept the recommendation made by the College Service Commission.
Kindly come to paragraph 25 of the judgment
25 of the
at internal page 10. May I place these paragraphs? I believe, my lord, I'll
25 we have considered the
rival
short
contention.
Short point that
Only, my lord, this is
In
relating to
this
the previous
my lord,
law
may I
and
make my submissions, my lord? When my learned friend will submit, I will not utter a word.
My lord, this is
My
relating
lord,
to the previous
my
law
lord,
and
kindly.
law has been changed. Then, my lord, let
yes,
him
yes.
complete his submission. Then I will show.
Yes.
The short point that falls for determination in this reference is whether or not the recommendation of the College Service Commission for appointment of a candidate is binding on the concerned college. The question for consideration in the judgments in the case of Dr. Such and Such was whether the claim of the first candidate in the list of selected candidates could be ignored by the College Service Commission and a person occupying lower rank in the list could be recommended. It was a case challenging arbitrary exercise of power by the College Service Commission, whereas the question before us is whether the college is bound by the recommendation made by the College Service Commission. No elaborate reasoning is required to demonstrate that these two judgments do not assist the court in answering the question. Now, my lord will straightaway come to 28. We are also unable to accept the submission of Mr. Mukherjee that recommendation by the College Service Commission is neither an advice nor a request. The dictionary meaning of the word recommend is to speak or write of or suggest as fit for employment or favor, to advise that a thing should be done. We are also unable to accept the submission of Mr. Mukherjee that the person selected has an indefeasible right which can be enforced by a writ of mandamus. He considered that in exceptional cases, a writ in the nature of mandamus may be refused. We are of the opinion that a writ in the nature of mandamus may be refused by the court for good reasons. We are supported in our view by such and such. Now, Lordship, kindly, if Lordship wants to see, I won't place the quoted portion. I'll straight away come to paragraph 31.
Yes.
At page 12. Section 7 of the West Bengal College Service Commission Act 1978 provides that the duty of the commission would be to select persons for appointment to the post of teacher of a college. Section 8 of the Act provides that the manner of selection shall be as laid down by the regulation. Section 9 stipulates that appointments to the post of teacher, which as per definition section includes a principal, shall be made on the recommendation of the commission. None of the aforesaid sections relied upon by Mr. Mukherjee makes it mandatory for a college to appoint a candidate recommended by the commission for appointment to the post of a teacher. Read together, the said section mean that no person who is not recommended or approved by the commission shall be appointed as teacher or principal. The final decision whether or not to give appointment to the selected person is in the realm of the college authorities. The decision must, however, be bona fide, free from arbitrariness, and in the best interest of the concerned institution. Now, my lord, will see, lastly, I'll place paragraph 33. As regards the submission of Mr. Mondal, who represented the College Service Commission, that there is no other source of appointment except section 9, we are in agreement with him to the extent that no appointment can be made dehors or ignoring section 9. However, it does not follow from the same that the recommendation of the commission under section 9 is binding on the concerned college. Such an interpretation of section 9 is neither warranted nor desirable. Lordship, this is the first judgment, and Lordship will see this is a division bench of this honorable court comprising.
This is 3 judges bench.
No, no.
3 judges. No, 3 judges bench.
No.
এই তো গিরিশ চন্দ্র গুপ্ত
And
It's a division bench,
no,
Lordship.
my lord, single bench conflicting judgment was my lord passed. That's why my
There are
lord,
5.
the special bench was constituted.
Motion
My
button.
lord,
2022. 2022.
This matter. This matter. Well, I shall my lord clarify that. What my learned friend is saying, I shall clarify them.
My lord, the other one I placed the 2022 decision of a coordinate bench. Bullet citation. Lordship, it is reported in 2022.
Yes.
SCC online, Cal
Single bench,
2282. This is a coordinate bench. Lordship will kindly come to paragraph 7 and 8.
Yes.
Lordship, my learned friend is just writing the citation down. Lordship will give me a second. Lordship will kindly take paragraph 2, para 7, page 2. According to counsel appearing for the respondent college, the present issue has been decided by learned single judge, as his lordship then was, by judgment delivered on 22/6/2020 in WP number such and such. The writ petitioner had approached the court with the plea that as a person with disability, the petitioner should be appointed to the post of assistant professor of Bengali in the concerned college. The court, however, found that the writ petition did not contain any evidence, refusing to appoint. The court accordingly of the view that the prayer of appointment could not be granted. The writ petitioner was, however, given the liberty to challenge the decision of the governing body, which was disclosed by the college in its affidavit. Now, Lordship, after that, the court held that the petitioner does not have a right to be appointed on the recommendation made by the College Service Commission, relying on a judgment of the Honorable Supreme Court. It reported in 2008, 1 SCC 318. The court also held that the recommendation of the petitioner by the College Service Commission for being appointed as an assistant professor of Bengal in the concerned college did not confer any right on the petitioner to seek appointment from the college.
It is beyond your headache. Whether you are bound to accept such, whether he has a right, that it is his claim.
My lord,
you cannot claim that his appointment and selection is bad.
My lord, I am not saying that. My lord, that is not my contention.
That I shall not take this person. No one take this person, and his rejection is bad.
No, my lord. Perhaps
just say that you are not bound to accept the recommendation of the commission.
Lordship. Now these are the
accept this.
Lordship. So
and
these
from that judgment, from the division bench judgment, it has said you have to show the reason.
Lordship. Now may I come to the reasons? May I come?
No one can be permitted to act according to his whims.
Without reasons. There must be reasons.
You run your institution from your own.
Lordship. I'll show it. I'll show it.
Seeking assistance from Service Commission.
Lordship.
Which is run by public exchequer.
Lordship.
What is this?
This is my affidavit in opposition. Now, Lordship will have to give me 5 minutes of time to explain one factual issue. My lord, the first thing is the documents which we are relying on to not accept the recommendation of the commission, we have not annexed with the affidavit, but we craved leave to place it before the honorable court. Well, this aspect was when the matter was taken up and the affidavit direction was given, I took the permission of the honorable court to do this, and kindly let me explain why. The documents which I will show, since my lord has put the query, I did not want to get into the issue of merits of this matter at all, because if the court is to get into the merits of the matter, the only person who will be prejudiced is the petitioner himself. We took a stand, Lordship, that we are unable to take this concerned gentleman in for certain reasons, but he may be recommended to any other college. It is not our, it does not line our Lordship. But for certain very fundamental reasons, we are unable to take the person in. Now, those reasons are of such a nature because of certain views and public posts which this person has been making from time to time on public platforms, which conflicts with the very fundamental ideology of this organization. Now, Lordship, kindly explain what I mean. Kindly let me explain. Well, the organization concerned here is an organization called Ramakrishna Mission, well, founded by Swami Vivekananda for not only for certain spiritual advancement, but spiritual advancement through carrying out of certain charitable functions. For instance, running of educational institutions, through establishing a hospital or other welfare activities. Now, Lordship, this entire organization is founded on certain core philosophical principles. The philosophical principle is, as propounded by Sri Ramakrishna, who is the fountainhead of this entire philosophy, is equal.
Philosophical, what you have said?
Well, this is the core philosophical basis for this organization.
Yes.
Is that all religions are true, all religions command equal respect, every man is equal, no discrimination on the grounds of sectarianism, religion, caste, or social identity. And the other aspect of the organization is that it is purely non-political. Now, Lordship will Lordship will kindly appreciate, I'm not placing the judgment here because by now it's
Now,
well.
in your requisition, have you mentioned this matter that
Lord-
we want such kind of who will confirm or who will agree with our ideology?
Now, my lord, may I explain why this is not
For you, a special interview will be taken.
No, Lordship, because usually
First number, do you agree with the ideology of this mission? Yes. Yes, 5 number. Do you not agree? Yes, 0.
Lordship.
In this way, that would be.
No. So in this case, what has happened, Lordship, is.
So you made the selection of your own.
My lord, we are an autonomous college. We have been granted autonomy by the university.
When you are sending requisition to the College Service Commission,
Lordship.
a commission who is also independent,
Lordship,
who cannot ask whether you agree to the particular ideology or not.
My lord,
Any candidate who will offer his candidature in response to the advertisement.
My lord,
he cannot. He should be against your constitutional duty.
Now, my lord, what has happened in this case is this sort of a situation has never occurred in the 70-year-old history of this organization, of this particular institution.
Suddenly, if I say, suddenly you are raising that we shall accept such person who will agree our ideology.
Now, my lord, if
have
I
you
answer,
written the Rajyog?
My lord,
have you written the Rajyog or Rajyog?
Have I?
The Swami Vivekananda read this book, even if you are an.
Rajyog, yes, Lordship, I have read Rajyog. I've read.
So the
I've
Swami
read.
Vivekananda can send a message who does not obey the religion.
Now, my lord, that's what I said. The principle is based on
what he posted. Give us.
My lord, before as I place it, may I just explain the reason and then I'll show the documents.
So now, that apart, what reason you showed?
Like, Lordship. So we have equal respect for all religions, which is why a person of any ideology can come in, provided the person cannot have a view which destroys the very ideology, because this is a right which is protected under the Constitution, under Articles 25, 26 of the Constitution for all institution, and it was held in Rohora's. But these are the documents. Now, I will show these documents, but I'm not giving a copy to anyone, Lordship, because these may prejudice the petitioner. Kindly read. These are the public.
We don't care, my lord. Let him communicate. It's a court of, my lord, affidavit, court of document. My learned friend is relying upon.
It's a court of certiorari as well. It's a court of certiorari.
That's your right. My lord, the thing is this, my lord.
My lord, may kindly read these documents, my lord. My learned friend will have his chance. Now, my lord will see. I have given two sets of documents. There is one document, Lordship, which starts with ব্যক্তিগত কিছু গুরুত্বপূর্ণ ঘোষণা.
Okay, forget he has some.
Now, my lord,
he
will
has
see
some
the kind of, my lord.
Now, show the reason.
My lord, those are the documents which I've handed over, Lordship. Those are
Yes.
My lord,
Court has have a glance.
Lordship. Now, Lordship will see. I'm constrained to make this. I would not have made this submission in open court. The monks of the concerned organization are compared with swines and tapeworms. Swines and tapeworms. These people are swines and tapeworms.
Advocate Learned Council,
Lordship.
I shall request you, court
Lordship.
has a limited time.
Lordship.
Court cannot give much more time, and don't say that anything about the long speech about the philosophy.
Lordship.
Court is just interested to give judicial answer. I shall give what
Lordship.
the judicial answer
Lordship.
to the law. You have presented, the question was put to you that whether any particular college can refuse to accept the recommendation of College Service Commission.
Lordship.
Despite sending one requisition, okay, for a
Lordship. Lordship, I've placed the two judgments.
Okay. You have placed the judgment of the division bench.
Lordship.
Okay. Now division bench says, yes, section 9 does not say that such recommendation is binding. Our court directed that if you want to refuse,
Lordship.
If you refuse to accept such recommendation, you have to show reason.
Lordship.
Now, whether you have showed some reason,
Lordship, this
how
is
and where?
So, Lordship will see that the documents that I've handed over, Lordship will kindly read through these documents.
Personal view, and he has
this is the view. This is not, Lordship, this is not a personal view. These are views put out in the public domain, in open platforms accessible by all 7 billion people on earth. Anyone can log in and see this. Today, if Lordship Googles, Lordship can see these views even right now. This is the public standing views, public views, not personal views, public views of an individual. Time and again, this goes on for 50 pages. This is the kind of views that the gentleman professes for the particular ideology and this organization. This organization is vile. They are like tapeworms. They are monkeys. My lord, I'm sorry to use these words because since my lord asked me to give the reasons, I'm giving the reasons. That this organization comprises monkeys. They are tapeworms. They are vile creatures. They are only up to monkey business. This philosophy is all, I'm not using the expletives, are all completely bad. Bad. These sort of person should not be permitted to carry on. Now, the same person wants an appointment in this institution to teach. Thereafter, Lordship, when this person is called, he visits the college and he is informed that, look, due to certain very fundamental reasons, because this philosophy stands at the core of the organization. The organization exists because you profess a respect for every faith. But if your view is like this, not only towards the faith, but also towards the organization specifically, then we said that we are unable to accept. Now, Lordship,
you send
we had a physical meeting. We had a physical meeting. Now, thereafter, after the physical meeting, we send a formal letter to the School Service Commission indicating these reasons as to why we are unable to accept.
This letter has been brought on record?
That letter has been brought on record in the affidavit in opposition.
Your affidavit in opposition?
In our affidavit in opposition.
Okay.
Now, Lordship, I will place that letter.
affidavit in
Lordship will kindly see
three, yeah.
page 13
Page
of my-
13, yes.
of my affidavit.
Lord, may I take leave, my lord, for 2 minutes? May I take leave for 2
No, no, one thing, take leave, where you will go?
Code number 2, my lord. Just I am coming, my lord.
Okay.
May I place the letter? Petitionটা দাও তো, writ petitionটা।
Yes.
Well, so we communicated these reasons. Now,
There are any other judgment except than 216 judgment?
my lord, there's also a reference to a Supreme Court judgment of 2008. My lord, I'm not placing that separately because I feel the division benches categorized the law and the single judges followed the Supreme Court. Therefore, I'm not placing it separately. Only one thing I want to point out. The other reason why I say that this honorable court should doubt the bona fide of the petitioner. Now, Lordship, when this is happening, kindly Lordship will see the pleading in the writ petition. May I take my lord to?
Yes.
Paragraph 26 of the writ petition at page 13. Kindly see the language used.
Yes.
That the petitioner states, and Lordship, these are all monks. These are all elderly monks. States that the Assistant Secretary of Respondent number 2 started yelling at the wife of petitioner for submitting the representation from the petitioner on such and such, narrating harrowing experience, whereas on that this very person has to submit representation. Shockingly, Assistant Secretary claimed that enjoys a special status that allowed them to accept or not to accept. This is incorrect. Lordship has seen my letter. Now, Lordship, para 27, the petitioner states that no such disclaimer about special status was provided. This is all again incorrect. Only announcement about respondent 3, which was made before counseling, was that lady were not eligible, barring that no other special requirement was mentioned, and there was no mention of any discretionary part. At this point, Assistant Secretary of Respondent number 2 displayed a malafide outburst of temper, raising his finger and his voice at the petitioner and his wife, completely disregarding the decorum of the office, and suggested that the petitioner should get job following footsteps of others. The petitioner at this point reminded the Assistant Secretary that the petitioner is a permanent faculty at such and such and will not accept this kind of misbehavior and will seek legal recourse, and left the room. However, the wife of the petitioner, anxious at the sudden unfortunate turn of events, remained at the office and was subjected to further humiliation. That the sudden turn of incidents led to the aged mother of the petitioner fell ill and had to be taken to doctor. Thereafter, in para 28,
that means the official of the mission met with the petitioner.
Misbehaved with the petitioner. First of all, this is a disputed question.
Number 2 is College Service Commission. See, my lord, cost title.
Oh, respondent number 2.
It is none of his business, my lord.
No, Lordship.
Kindly see, page 14, my lord, respondent number 2 displayed a malafide outburst of
My lord,
temper.
this was.
Kindly see, this is the respondent number 2, and respondent number 2 is, my lord, the College Service Commission. Secretary, I am making certain allegation against College Service Commission that at that point of time they did misbehave with me. That is what I am writing over here.
Lordship, that first of all, I wanted to point out that this is a disputed question.
No, whether you have any judgment to contrary to this proposition which laid down a contrary proposition to the judgment of 2016.
My
judgment is there, Mr. Chakraborty. Any
The
judgment
law has been amended. This is relating to, my lord, 1978 law. And my lord, new law has been come in. I may be allowed, my lord, to submit. I will produce all the documents. And now it is incumbent upon the authority to accept me
Now, my lord, I have cited the.
my lord, I'll show.
My lord, I have relied on the latest judgment being of 2022. That it is not.
2022 relevant page.
Lordship, that was paragraph 7 and 8.
Paragraph 7 and 8 is a fact according
No,
to.
Lordship, there's the proposition has been mentioned by relying on a Supreme Court judgment.
That is another.
Lordship.
That is another. Mere impediment, or since the commission has recommended, he has no right.
Lordship, that is
indivisible.
Lordship. All the time, all that I was submitting humbly, all the. Now, Lordship.
Issue is whether a college can refuse to accept the recommendation made by the commission or not.
Lordship. Now, the last thing I will place, Lordship.
Why court is interested? Maybe in your case is totally different case.
Lordship.
In every case, college will claim that liberty.
Lordship.
Okay.
Lordship.
And the order which will be passed, that would be law for our state.
Lordship. In fact, if it's a central statute, it will be law for the
In
entire
that,
country.
all the college, in refusing to accept such recommendation.
Now, my lord, what
tomorrow ABC college will also say, look, that judgment, I shall not take it. Go elsewhere. I don't know.
Now, my lord, the question will be whether the recommendation is
Maybe
not.
Here is the cause is that he is not agree with your ideology.
Not just.
In that, there may be a different cause.
Now, my lord, it is not a case of not being agreeable. It's a question of having defamatory, insulting, humiliating, and fundamentally antagonistic views towards this very institution. This very institution. Now, my lord, I, under Article 25 and 26 of the Constitution, Lordship will kindly. Just a moment. May I just place this?
You have a right to propagate your own philosophical, religious.
And now, my lord, I don't have the
practice
judgment.
And propagate.
Lordship.
Yes.
Lordship will see.
Manage religious affairs. Yes.
Lordship. Nothing in this.
None is restraining you, and none is snatching away the right conferred upon you by our constitution, that you will not be able to practice, propagate, and manage such affairs. You do according to your constitutional right.
Lordship.
But when you will start to operate one educational institution and to fill up its post, you will send a requisition to the one commission.
Lordship.
Set up by our state.
Lordship.
To make such recommendation. Now, despite sending requisition to that commission, when commission in response to your requisition has made the recommendation, can you refuse to accept the same? Raising various pleas. Here, that he has made some derogatory remarks against your institution.
Some, no, all the time, everywhere, throughout the public. That is the case, Lordship. All the time, everywhere, across the public.
That's all your submission.
Lordship. And my last submission would be, Lordship put a query to me that when we ask for the requisition, why did we not specify that you cannot have have certain ideological beliefs? Now, to that, Lordship, I respectfully submit the ideological beliefs which we profess is also the ideological belief of our constitution and this country as a whole. This is the kind of view which every individual in this country has to have. Because if he doesn't, he is in violation of Part 3 and Part 4 of the Constitution, and also Part 4A, which is our fundamental duty. Therefore, for me to seek a person who holds views which is also the view of the Indian state itself. I do not need to specify it separately that you please recommend a candidate who conforms to the beliefs of the India's constitution. On the contrary, if a person professes beliefs which are contrary to the very basic structure of our constitution, then there is an issue, Lordship, which requires to be specified, which requires to be dealt with. But if I say that your views are fundamentally opposed, because Lordship will see this particular philosophy and the philosophy of the Indian state are one and the same, which is one of the reasons the particular organization enjoys a certain reputation worldwide. Across political lines, across caste lines, across religious lines, it enjoys a certain reputation. That is not just for the institution, and also my last.
Where is Mr. Panda?
He is code number 2, my lord.
Oh.
Now,
Now, whether you are saying that law in the meantime, law has changed.
Before that, my lord,
You just show that law has changed. Section 9.
I'm showing, my lord. Two,
Okay.
three aspect of factual aspect.
Factual aspect, court has got the fact.
Yes.
That is sufficient. You
Yes,
just.
yes, my lord. This is, my lord, the new law.
This is the College Service Commission
Yes,
Act.
2012.
2012.
12.
This judgment of 2016
relied upon the judgment which is relating to the previous act. That is also I'm showing, my lord. The judgment is also enclosed here with. I had apprehension, my lord. This judgment will be relied by my learned friend. My lord, that is the last enclosure, last 2-3 enclosure. I'm coming, my lord. Lordship will find the judgment is here. Lordship will find the act which was taken into consideration by the Honorable Division Bench is relating to, my lord, 1978 Act. Kindly come to my lord. Lordship got the judgment.
Yes.
Regulation 9 of the regulation framed under the 1978 Acts. I am reading, my lord, page 2 of that judgment, my lord. Here, my lord, Lordship, after 1978 rules, Lordship will find the judgment of Justice Girish Chandra Gupta and Honorable Chief Justice, as his Lordship then was, and Mr. Justice Purijit Banerjee. Lordship got that judgment.
Yes.
Then Lordship will get the
32, para 32, yes. Para
78.
32, 31, yes.
Yes, 70. Then I am drawing Lordship attention. 2012 law. Lordship, kindly come to my lord. Page, paragraph, Lordship, kindly come to my lord, page 2 of that law. Definition. 2(9). Constituent college means a college recognized as such by a university but does not include a government college. My lord, they are getting all benefits from the state of West Bengal, but they are not the government college. Then, my lord, kindly come to governing body 11. Means the governing body of a college and includes any managing committee or any other committee which is in charge of the administration and function of the college as may be approved by the state government and also includes an administrator. If they are of the opinion they have taken unanimous resolution by the governing body, then they have to show that governing body is duly approved by the state government. Then, my lord, government aided college 12 means a college which is under the pay packet scheme of the state government. They are under the pay packet scheme of the state government. 12, 212. These are the definition clause. Then, my lord, I am drawing Lordship attention.
The college is a government aided college.
Aided college. So, my lord, they have to depend upon the government, not that they are independent. And my lordship, kindly recall, my learned friend, my lord, referred Article 25, 26. Once they have ventilated their grievances before the Honorable Supreme Court, that was reported in the 1995, that the minority within the Hindu, that was rejected by the Supreme Court, as a result of which, my lordship knows, my lord, the linguistic minority and religious minority are controlling their own faith, like St. Xavier's College. And linguistic minorities are also there. That was upheld by the Supreme Court. So far the contention of Ramakrishna Mission is concerned, at a point of time, it was ventilated before the Honorable Apex Court. Apex Court was not in a position to accept their contention, their minority within the Hindu community. So that being the situation, they are not in a position to control their own fate. They are not in a position to appoint their own teacher. They are to accept, my lord, the help of the state, and they are the instrumentalities, and they are substantially, my lord, financed by the state government, and they are running their, my lord, doing all these things. Yes, my lord, they have the reputation. They have earned the reputation, and that is why this writ petitioner intends to join there. That is why Myself is, my lord, the PhD in, my lord, lordship knows the name of the Terry Eagleton. My lord, he was, my lord, doing work in the Karl Marx. And maybe, my lord, I have some inclination of leftist ideology. Myself is doing, my lord, the work of Alia University. I know number of Hindu teachers are working there. If Alia University today or tomorrow set a particular, my lord, the condition, Hindus are not permitted, then, my lord, things of, my lord, the secularity will go immediately evaporated. Immediately evaporated. My lord, the Ramakrishna Mission, we know the name of Vivekananda, everyone knows. My lord, the liberalism, my lord, is there. And my lord, the thought of the Vivekananda, my lord, spread over the whole country. In spite of his
You
yes, I'm coming, my lord. Seven, my lord.
You said that now the
seven,
college
seven.
authority has got
My lord,
no power to refuse such recommendation.
Seven,
You
section
take
7.
the court to that year.
My lord, section 7. Notwithstanding anything contained in any other law.
Section 7.
Yes, my lord. Page 7, section 7.
Okay.
Notwithstanding anything contained in any other law for the time being in force or any contract, custom or usage to the contrary, it shall be the duty of the commission to select person and to recommend the appointment to the post of principal, assistant professor. Myself is assistant professor. Then, my lord, the member of the commission shall render necessary advice to the chairperson for preparing panel. I'm skipping. Then, my lord, 4. For the purpose of recommendation of eligible candidate in each post under this act, the commission shall follow a counseling process as may be provided by regulation. This is the, my lord, section 7. Then turn to, my lord, section 9. Next page, page 8.
Yes.
Procedure for conduct of the business of the commission shall be such as may be provided by regulation. The state government may give direction to the commission in conducting their business, not repugnant with the provision of this act. Then, notwithstanding anything contained in any other law for the time being in force or any contract, custom, usage to the contrary, appointment to the post of principal, assistant professor, librarian of the government-aided college in West Bengal shall be made on recommendation by the commission. Provided that if in a college referred to in this section, no student is admitted in a particular subject, myself is English, or for two consecutive academic sessions, the commission may, with prior approval of the state government, re-recommend such assistant professor of such subject to another college having such post in same subject where such students are available. So, the only proviso is there. In the event no student, re-recommendation is permissible. Here, my lord, my rank is better than everyone. Rather, here, my lord, they cannot re-recommend me. I am leaving.
What that thing that now the college is bound to accept.
I'm coming, my lord. I'm coming. That I'm to show, my lord, the rules at the same time. This is one thing, my lord. Re-recommendation is only possible because in the event of no student. Then, lordship, kindly come to my lord.
When
rules.
a person asks you for a glass of water, you give that glass of water first, then you give another thing.
I'm coming.
Serve another thing.
I'm coming.
Okay. Court is asked this question, neither you are in a position to satisfy.
I'm coming. I'm coming, my lord.
Whether is bound or not.
I'm coming, my lord. The West Bengal College Service Commission regulation may kindly be looked into after the law regulation is there. This was amended in the year 2012. This is section 3, my lord, information regarding vacancies. Then lordship will come, my lord. 6, selection of candidate on the basis of advertisement, written examination, panel of candidates. Then lordship turn to, my lord. 9, counseling. The empanel page, my lord, this is page, internal page, my lord, 8. The empanel candidate under each category, such as unreserved, SC, ST, OBC, A, B may be called for counseling one by one, strictly in accordance in order to their merit, and be given the opportunity to choose the vacancy under respective category of his preference from amongst the one and that still remain vacant when his turn comes. My turn comes, I have decided to, my lord, take Narendrapur Ramakrishna Mission. The vacancy chosen by the topmost candidate in rank amongst the remaining one in the panel shall be allotted to him. That being the situation, my lord. Then, my lord, once a candidate exercises his choice, next, he shall forthwith forfeit his right. Then, my lord, kindly come.
You are reading?
My lord, I'm reading, my lord. Counseling 9.3. Internal page 8, 9. At the top 9, my lord, lordship got it? 3.
The first portion, the act.
No, rules. Now I am drawing lordship.
Or regulation.
Regulation, my lord.
Regulation 9.
Regulation 9. counseling. 9(3). Once a candidate exercises his choice, he shall forthwith forfeit his right to choose any other vacancy, and refusal to choose any of the remaining vacancies at one turn shall automatically cancel the candidature of that candidate, provided the candidature of an impanel candidate may be treated as cancelled if the candidate fails to attend the counseling on the appointed day and time. So, my lord, I have selected a particular college. I intend to go there and join there. And lordship kindly see.
That is not to.
And my right is forfeited. And if they do not permit me, my lord.
Okay, now you want to
Only one
allow
provision.
the court to conciliate the dispute.
Only one provision.
You, Mr. Panda.
Only one provision before that. Only one provision.
Yes.
My lord, 11. Power of the commission, general power of the commission. The commission shall have the power to determine every question which may arise in the selection process. Lordship knows, selection process means, my lord, which includes appointment. The commission shall
include counseling and include the choice of school also.
Yes, my lord. Selection process means till my appointment is taken place, since I forfeit my right selecting particular college. So, my lord, this is their duty. Now their duty after 2012 amendment, in a manner not inconsistent with the provision of the Act and where necessary in a consultation with the state government. Well, that being the situation, this is the amended provision of law. So far, the earlier 2016-17 judgment lordship examined, that is relating to 1978 judgment, 78 law. My lord, that provisions was not available there. If this honorable court kindly permit me, I'll show, my lord, the provision of 1978. And my lord, here they have very categorically stated 1978. That is also there, my lord.
Yes.
My lord, here they have very categorically stated obscenity, disparaging remark.
No, I shall not allow you to go that. What is the obscenity? What is disparaging? I shall not extend.
Only one thing.
I shall not extend the scope of litigation. Mr. Panda, rightly or wrongly, a dispute arose regarding acceptance of this particular gentleman by the Ramakrishna missions. According to him, that he is against the ideology of the Ramakrishna mission. That is mere a counseling. Okay, mere a counseling. So, to avoid any dispute and to you think you recommend this person for another college and you send another college to, that would be better.
I can understand your loss.
That would be better if you want to take.
Difficulty is the panel has been expired. As the panel has been expired, no one can be recommended.
Lordship only decides.
Panel has been expired. Actually, the recommendation which is made, he has not been completed. The process has not been completed as yet.
Subject to correction, the power of the commission is very much limited. You will not advertise for the post of assistant professor, the intended applicant to be applied, and then, my lord, we shall start the selection procedure. We have, after the interview, we shall prepare, my lord, the panel. Then, my lord, the panel has been published. The regulation says the panel remain for 1 year. And, my lord, within the 1 year, and our, my lord, regulation says before publication, I have to, my lord, publish the vacancy list, tentative vacancy list. And whatever the requisition we have received, valid and proper requisition from the concerned colleges, after verification and authentication by the
again, making submission regarding the law. Court is not on law or legal aspect or right. Because the court has every power to settle the matter at any point of time, any APCON judgment and such and such. Okay. So you take, if you don't say, cannot say here and now without instruction, you take instruction whether you are in teaching Bengali or English. English. You made recommendation for this particular gentleman for another college, and in the next time the mission will get the teacher.
Subject to correction.
Or in the next year.
Whatever document directing me, I have to comply. But the difficulty if any vacancy arose after cut-off date, we generally not recommend. But the one judgment passed by this Honorable Court, my Lord Justice Kaushik Chandra, that even after the expiry of panel, the vacancy arose after cut-off date, you have to consider. I have, my Lord, considered, my Lord, I have, my Lord, accepted this judgment, but subsequently accepted judgment in the sense, my Lord, we prefer an appeal. Appeal court has, my Lord, upheld. In the meantime, my Lord, the contempt was proceeded, and we have, my Lord, in compliance with the order of this single bench, we have complied. We have preferred an appeal before the SLP. SLP has, my Lord, says no. No one can be recommended after expiry of panel, and even after expiry of panel, if there is a vacancy has been arose after cut-off date, you cannot. My Lord, I have that. This is, my Lord, my Lord, standing in my face.
Now, after cut-off date is not clear. If you notify a vacancy,
Yes, my Lord.
then that vacancy must be reserved for that selection process.
Yes, my Lord.
You cannot fill up that vacancy from by any other candidate
Absolutely, my Lord.
who have not participated that selection process. But have you ever initiated any selection process?
Yes.
If any such vacancy is available to you,
Because of 2020 vacancy,
which has not yet been notified,
2020 selection. This is, my Lord, 2020 selection. Has been, Lord, ended 2020.
But there are number of judgment, my lord.
Just have to believe. My Lord, we have published the merit panel. Before that, we have published the vacancies. We have indicated that the cut-off date from the date of publication of the vacancies. Whatever vacancy arose within the, my Lord, cut-off date before publication or on the date of publication, we have to consider. The panel remained for 1 year. Those vacancy has not been received, or, my Lord, the proper requisition has not been. Although the vacancy occurred before publication of the merit panel, we have, my Lord, given recommendation within the merit panel, within the my Lord, validity of merit panel. But the panel has been expired. And, my Lord, if there is no vacancy today, I have to take instruction. If there is a vacancy within the cut-off date, then I can, my Lord, accommodate. But if there is no vacancy, then, my Lord, difficulties, my Lord, to, my Lord, accommodate in the future vacancy which has not been occurred, my Lord, before publication. If I have done, then, my Lord, I shall, my Lord, violate the Supreme Court order. This is, my Lord, 2020 is 2022 principal selection in respect of, my Lord, in respect of Sudeshna Lahiri's case. Honorable single bench has categorically, same submission was made, that was, my Lord, turned down by the Honorable. No, you have to give the vacancy, because even after expiry of panel, the vacancy occurred, ongoing selection within remaining the validity of panel, you have to give. And we prefer an appeal court, we have lost. Then, my Lord, Supreme Court, we have, my Lord, categorically said no. Then, if the vacancy occurs subsequently,
yes, there is the
then
one saying, future vacancy is for future generation. Not this generation.
I shall come. Yes.
Future vacancy for future vacancy generation.
May I
take my lord's
Yes.
Obviously,
Okay, I am. You take instruction. I am keeping it under the
only
heading
one
for
difficulty.
order. If anything can be done.
Only one difficulty I am apprehending, my lord. Supposing, my lord, Mr. Panda is kind enough to allot me a seat in Siliguri, but I have left Delhi associate professor post, coming here as an assistant professor to learn, my lord, a reputed.
So you are the creator of all problems.
True, my lord. If that be so,
You are interested to enter into the
today, if I create the problem, my lord,
and go on.
is it so? Is it so? Their internal inquiry proceeding is
Hey,
not
আপনি
there.
এক কাজ করবেন তো একটা খামে পড়বেন পুরো আমার কাছে দিয়ে দেন
My lord, the disciplinary proceedings, my lord, they can very well accept it, but take against me in the
you have
event.
no right. You have not at all an employee.
After the employment, in the event I make such
What
comment,
I can.
they can take action against me.
So go on, do. You are not required to do the job. You go on.
This may be, my lord, the observation. Lordship kindly
You
recall
go
the
on.
Shodon Singh judgment. My lord, there was, my lord, some comments.
Biplop,
If a
Biplop,
person-
go on doing Biplop.
If a person makes certain
But
comments,
not square.
my lord, he is not entitled or eligible to take a government job.
My lord, do not take any, my lord, because of Lordship has, my lord, directed to, my lord, accommodate.
Take instruction whether he can be accommodated in his. Yes, yes, yes.
So obviously, my lord, if Lordship has directed, I have to, my lord, comply. But, my lord, I have to place that there is a judgment. That's why, my lord, I make submission.
Yes, yes, give us the judgment, give me the judgment. You ask your junior, get it Xerox and hand over to you.
I shall.
And in that case, my lord, kindly allow me, my lord, to rely upon certain judgment, obscenity, disparaging remark.
No, I shall not allow you.
What it constitute? My lord, they have made such allegation against me.
Before that, my lord, my
And say a single judgment.
two judgments. One, my lord, the Prashanto Sen case, which is now, my lord, appealed before the Supreme Court. Supreme Court has, my lord, SLP has been accepted. I appeared before this honorable court.
Which judgment?
Division bench judgment.
Division bench, SLP is pending.
And not only that, the single bench judgment which has relied by my learned friend, kindly the last paragraph. Last two paragraphs, very important, my lord. My lord, the Arun Sarkar judgment which my learned friend has, my lord, relied. My lord, I had to occasion to appear before this court and argue. My lord, paragraph 36, 37 and 38, Lordship kindly consider. This is the case of 80% handicap. 80% handicap. The college authority has refused to accept only on the reason because of he could not, my lord, move to class. 80%. For that reason, the college authority denied to, my lord, issue appointment letter. Despite that, my lord, paragraph 36, the honorable court has directed to revisit your regime. There cannot be a denial of the fact that the governing body of the college has a duty to act responsibility and sensitively. Having regard to the statutory provision, the governing person with disability, it is all the more surprising that the governing body directed the chairman and secretary of the College Service Commission to replace the recommendation of the petitioner by another one of the same category. Towards the further integration, the impugned decision also give a rise to serious civil consequences on the right of the petitioner to specific and person with the disability in general. This court find that the impugned decision to be a denotes what they having regard to the provision of 1995 and 2016 Act and bearing the direct contradiction of the objective sought to be achieved by the statute, the decision deserved for the cause and set aside. Then, my lord, while the court may not appropriate into itself to power to recommending the petitioner for appointment, the court deems to be fit direct to the governing body to arrive at a fresh consideration at the fact before the revisit of issue with due regard to the statutory mandate. And Prashanto Sen judgment was decided on the basis of 1978 Act. And subsequently, this act has been repealed and new act has come into force 2022.
But 2012, but there was no clear mandate that the college authority is bound to accept.
The difficulty is, my lord, apart from College Service Commission, no one, there is no
appointment shall be made except on the recommendation by the commission.
No one can selection 7 except my lord College Service Commission.
And I am to
Only.
I have to forfeit my right.
Only.
After selecting one college.
Only, my lord.
What will happen? I am in a no man's land. I am in a no man's land. I have forfeited my rights. And they are not in a position to accept.
Today, my learned friend submitting that some comment has been made by them. But being a College Service Commission, every day we are facing. Then, my lord, the candidate who, my lord, making comment, we are not, my lord, giving opportunity. If he has, my lord, empaneled, we are not giving him to, my lord, a recommendation.
If it is a penal offense, they can take action against me.
My lord, last, my lord, 7 years, I am, my lord, appearing on behalf of the College Service Commission. Every selection, Everybody has, my lord, making comment before the media. Even, my lord, taking in the name of the chairman. Though, my lord, that College Service Commission has, my lord, disqualify him, debate to, my lord, recommendation. Is it the reason, my lord, I am putting this question to myself? And what is, my lord, the comment as, my lord, made by the petitioner? The college authority wrote a letter to the, my lord, College Service Commission. Kindly see.
They have annexed their opposition, yes.
They have annexed their opposition, my lord, many of the comments. What, my lord, they have reason to, my lord, issuing, denying to, my lord, the appointment letter. That is, my lord, I am placing before lordship my opposition. Only this letter they have, my lord, given us. Only, my lord, kindly see page 12 of my opposition.
Therefore, respondent number 2.
Sorry, my lord, page 10.
Yes.
Page 10.
Yes.
I am skipping, my lord, paragraph 1, 2, 3. Only, my lord, the governing body is unanimously viewed that the Sri Dasgupta's strong view, religious and society, displaying hearted and making the offensive remarks towards another religions or ideology, or completely unethical to the fundamental idea and philosophy of Ramakrishna Mission, which is essentially unity and equality of the religions of the faith. This is only for the comment. This is only for the reason, my lord, they are asking for, my lord, not to giving any appointment. If today I have, my lord, withdrawing his recommendation. Tomorrow, if I recommend anybody, then he might be, my lord, make any comments. Then his appointment to be recommendation to be withdrawn. I'm not, my lord, against the Ramakrishna Mission, but the question is, you have make a requisition. I have, my lord, judged his, my lord, the qualification and, my lord, quality. Then, my lord, I have been empaneled. Then, my lord, according to, my lord, rank, my lord, the recommendation has been made by way of counseling. The college service, the college authority, their condition only one. No, my lord, the woman candidate to be recommended. We have, my lord, accepted.
Women, you are women.
No. Here, my lord, Ramakrishna Mission, the first condition, College Service Commission should not recommend any woman.
That was adhered to by the.
That is only condition. If every day, today you are doing, tomorrow other college will, my lord, refuse to giving appointment. Then, my lord, what is the purpose of this act? What is the function of this College Service Commission?
Initially, they impose a burden that don't send any woman.
Yes. And we have accepted that because their ideology that they will not accept it.
You have accepted the same.
Yes, we have accepted. We are not recommending.
Paragraph 11, my lord, the no lady candidate was eligible to choose the associate college. That is the conditionality set by the Ramakrishna Mission. It was adhered to by the College Service Commission. My lord, today, my lord, if this happen, tomorrow Alia University will come forward and take the particular plea. No Hindu will be allowed to in our institution. Then secularism will go, certainly. And over and above the judgment relied upon by my learned friend, from that college, this gentleman was the teacher in charge. Defalcation of money related complaint was against him. Now he has been selected as a principal. Then college governing body was of the opinion, a person who, against whom, my lord, the defalcation charges are there, we are not going to appoint him. That was accepted and adhered to by the Honorable Division Bench. At the same time, my lord, it must be bona fide, reasonable. If I have done any offense, my lord, they can take penal action against me. Neither it is obscenity, not disparaging remark. Tomorrow I will be appointed. In the event I carry on and keep on, my lord, making all such comments, they can take disciplinary proceedings, my lord, against me. Obviously, internal, my lord, disciplinary complaint, disciplinary action may kindly be taken by them. Be taken.
The entire power has been vested to the college to initiate the disciplinary proceeding.
And these.
Okay, so I am keeping it on Monday. Okay, Monday. এটা forward
Your lordship, your lordship,
Judgment, my lord.
your lordship,
Obscenity and disparagement.
whatever judgment you
lordship.
want to rely upon, you hand over the same.
your lordship, can it be kept on Tuesday, your lordship, because of Mr. Deepan Kumar, I'm being led by Mr. Deepan Kumar Sarkar. He's unavailable on Monday. Your lordship, on Tuesday, your lordship, please.
Tuesday হবে না তাহলে।
Under the heading to be mentioned, my lord, since my lordship substantially heard this matter.
হ্যাঁ?
Under the heading to be mentioned, my lord, substantially heard this matter.
হ্যাঁ, সোমবার তো আবার ইয়ে মঙ্গলবার দেওয়া যাবে না না ওর কথা শুনে কি হবে? আপনি কি সোমবার বলতে কোনটা? ও 30 আচ্ছা, 1 জুলাই কি অনেক কম আছে?
Friday, my lord.
আচ্ছা ইয়ে 1 জুলাই, ওকে 1 জুলাই,
Okay, your lordship, grateful.
1 জুলাই, আর নাহলে আর একটু আর করবে ডেট আছে দেখুন। 4th জুলাই স্যাটারডে, Friday, or 4th July.
4th July.
In the meantime, you all submit the judgment. Okay, copy of the judgment, what you are.
Whether this honorable court requires a written notes of argument.
Eh?
Whether this honorable court requires any written notes of argument. If this honorable court directly, I can come, my lord. But I am very much aspirant to be there, my lord, because in MA, they are holding, my lord, MA classes also. Let that being the situation. And what if I make any remark and keep on making, they can take disciplinary action in future. Not that they are, my lord, any manner, my lord, prevented. Today I am against the monk. Tomorrow I may be the part of this.
Such a hard the learned advocate appearing for the respective party leads the matter under the heading forward. So the parties has liberty to file their written notes of argument in the meantime.
Deeply obliged.
Okay.
And in the meantime, I shall
Huh?
in the meantime, I shall take instruction if there is any vacancy.
The Mr. Panda, learned advocate representing the College Service Commission, is requested to take instruction whether the petitioner can be accommodated in any suitable vacancy or not.
College.
College. Vacancy means college, any suitable
Lordship at the
college.
same time knows, my lord, 66A of Information Technology Act. Shreya Shinghal
Your lordship,
comments in the Facebook, comments in the social media. That was, my lord, the Supreme Court was kind enough to delete this portion from the Information Technology Act. That judgment is also with me. If this not
your lordship, one humble submission, your lordship. The judgments they are relying, if they can give us an advance copy of those, then we will be able to deal them in the notes, because we have given our citations to both the parties, your lordship.
Okay, if you give this, I will give the submission. Yes, next.
Grateful, your lordship.
কালকে কি আছে? কালকে কি?
Of the respondents, my lord.
Your lordship, Mr. Ujjwal Rai is appearing for the petitioner. He is on leg in court number 6. I am only praying for a short passover. Your
My lord, my lord, it is 2017 matter, my lord. There is a direction for, there is no direction for affidavit. There is an order, a rescind order, rejecting her prayer of compassionate appointment, my lord. My lord, without opposition, matter cannot be decided, my lord. My lord, kindly give us direction to file affidavit, my lord. Without affidavit, matter cannot be decided. There is order of rejection by this Director of Library Services, my lord. It is at page, my lord. Starts from page 45, my lord.
Your lordship,
The order impugned, my lord. Kindly have a look. to
my
page
senior is
45.
on leg in court number 6, your lordship. Only a short passover.
P10.
Let him come.
My lord, direction may be given to file opposition, my lord. Without opposition, matter cannot be decided, my lord. We want to file opposition, my lord. From 2017, there is no direction.
No,
but-
I am thinking whether I shall pass in their presence. Then
My lord, order for
let
opposition, my lord.
same order be passed in their in
Your
presence of Mr. Roy.
You can make it not today, my lord.
Not today. What matter is going on? When you will.
Mr. Rai is on leg at court number 6, my lord.
that he is seeking leave to file affidavit in opposition.
My lord, what was falling from my lord, I also pray for that, my lord. Let this order be passed in presence of Mr. Rai, my lord.
My lord,
Because I believe, my lord, this matter will not require
he
opposition.
is junior of Mr. Rai, my lord. There is
Yes, my lord, what I was,
Let him come.
I'm grateful. I'm grateful. If my lord can he makes it not today, then my lord.
Not today.
Not today.
So come tomorrow.
Grateful.
Come tomorrow. Yes. Next. Petitioner.
এদিকে 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 এদিকে
এই দেখুন এইগুলো সেই এই যে ইয়ে হচ্ছে না ব্যাপারটা সব আপডেট করার জন্য মাথা খারাপ করে দিচ্ছে What's the matter about?
The matter is the unauthorized construction, my lord. I'm enjoying the interim order, my lord. Since now they are not filed any affidavit. And I filed an application for subsequent development, my
Pulling
lord.
down and demolishing the illegal unauthorized construction raised by the respondent number 6 over the plot of land of the petitioner.
Yes, my lord.
Huh?
Yes, my lord. Private respondent is also. I've also served notice, my lord, file an affidavit of service, my lord. All the respondent, my lord.
Who is for your other side, respondent number Mukarram Hossain.
Yes, my lord.
And state is Arun Kumar Rai in 2008.
Yes, served notice, Mr. Mokaram Motion is principal respondent, my lord, private respondent, my lord. He is doing all the mischief, my lord.
So their presence is required, whether you mention upon notice.
Yes, my lord.
Where is that mentioning slip?
Yes, my lord.
এই আপনি দেখে দেন না কোথায় কোথায় নোটিশ দিয়েছে হ্যাঁ
Yes, my lord. This notice is.
কাকে দিয়েছে মোকাররম হোসেন দিস ইনফর্ম কবে এটা 8/5
Yes, my lord. I have to serve notice.
So you give it another notice that the matter will be taken up for hearing on 9th July.
9 June, my lord. Kindly fix it.
9th July.
Time, my lord.
হ্যাঁ আপনি করবেন no time আচ্ছা আচ্ছা having heard the learned advocate appealing for the petitioner and upon perusal of the materials on the (28) bottom of the list.
Your Lordship, Mr. HON'BLE Rai is appearing for the.
Every matter.
Lordship, in this matter, I'm appearing on behalf of the respondent, Lordship.
Okay, bottom of the list.
Your Lordship, only not today, Your Lordship.
Okay.
One day, sir. Your Lordship.
29. Oh, okay, no, not today, but bottom of the list. 29.
29, my lord, I'm for the Union of India.
Very small innocuous spray, my lords. A plot of my land has been taken over for doing some infrastructural project of laying pipelines.
Huh?
My land, a plot of land which is owned by me, was taken over by the authorities for laying pipelines. Now, my prayer was for compensation. Lordship, a hearing was held way back in the year 2018 between me and the private respondent who was also claiming to be owners of the land. No result of the hearing has ever been given to me, and I do not know the fate of my prayer of compensation. All I am seeking today is that I am be handed over the result of the hearing. That is the innocuous prayer before my student. Lordship, kindly takes up page 71.
Land was acquired under which act?
Lordship, land was acquired under the Petroleum and Minerals Pipeline Act 1962. Lordship will kindly just see
what is the provision for apportionment?
Lordship will kindly see.
Apportionment, what is the provision relating to the
Section
apportionment?
10, my lords, of
Huh?
the Section 10 of the Act.
Who is the authority? Who is the authority?
Lordship, the authority is the competent authority or the district judge. The hearing
So you
was,
made application before
I have
the
made,
district judge?
I am saying that, my lord.
Ah.
I have made an application.
Ah.
I was called for a hearing.
Ah.
The hearing was conducted in the year 2018.
Ah.
Thereafter, no information. 71, Lordship will kindly peruse the hearing
The
notice.
district judge cannot see. District judge is not an administrative authority.
No, my
District judge, what is done, sitting his chair is a judicial function.
Lordship.
So there must be one miss case or anything like that was
Lordship
started
will kindly just take
based on your application.
Lordship will
So
just
that is number. If you think that that despite conclusion of hearing, district judge does not pass any order, your remedy lies in 227.
Lordship will just kindly just see page 71, my lord.
Give that answer, then kindly.
Lordship,
Give that answer.
Lordship, it was heard by the competent authority under 2A of the Petroleum and Minerals Act. May I just read this out, my lords?
You are seeking a declaration in the writ petition that a degree has attained finality.
Decree, my lords, decree is not.
Pair A, you read pair A.
Lordship.
Competent authority.
And your pair suggests that there is a dispute regarding apportionment of the compensation.
Oh, my lords, prayer A, my lord will just kindly skip. Lordship just takes prayer.
Declare a degree of a learned.
Lordship kindly takes a prayer B.
Civil judge.
Kindly takes a prayer B, my lords. Just kindly takes a prayer B, Lordship.
What is the number of the suit? What is?
Lordship, that decree is there. All I am today is on, my lords, that.
Now, whether his prayer is maintainable, his prayer
Lordship,
is.
prayer in. Prayer A, Lordship will kindly mold.
So, with your file
Lordship will kindly mold. Lordship will just kindly appreciate one thing, my lords. 2018, a hearing was conducted. That is a part of the writ petition. Page 71. The competent authority, we submitted.
Who is the competent authority?
Lordship, the competent authority over here was a person designated under 2A of the Petroleum and Mineral Pipes Act. Lordship, it is Holdia Boroni Pipeline Project. His name is also here, my lords. He has been appointed under the act to go into the district.
Who?
Lordship, an officer of the Indian Corporation. An officer of the, it's not the district judge, my lords. The section 10 says either the competent authority or the district judge can hear. Here, the competent authority who was appointed had called us for an hearing and he's heard the matter. Since 2018, man.
You are for the
Union of India. I'm not the competent authority.
requiring body. Who is requiring body?
The requiring body is the respondent number 3, Indian Oil Corporation Limited, my lords. Lordship.
Competent authority is Indian Oil Corporation.
Lordship.
Who is the
pipeline project?
Now, Lordship, they had not been appearing. Lordship will kindly take up page number 3.
Okay, who served?
We had served, Lordship, the notice we've already handed over. It's served again. We served pursuant to the order of my lords. What are the notice, sir? Lordship, the matter came up. Lordship, that is the old affidavit of service. That is the old affidavit of service, my lords. Thereafter, when the matter was placed before Justice Basu sitting in the coordinate bench, he had asked us to serve a notice on the lawyer. Lordship, the notice has been handed over. Lordship, may kindly see. In pursuance of Justice Basu's order, we already served.
Whether you mention this matter upon notice.
Another thing, my lord, I think the LA collector is also a required party because LA collector is the person who acquires.
So the upon notice you mentioned that this matter will be mentioned. এটা মার্চে আমি ছিলামই না বেঞ্চ
না এটা এখানে আপগ্রেড করার জন্য কিছু এখানকার আপগ্রেড করার জন্য চিঠি দিয়েছিলেন।
Another thing, my lord, LA collector is also a required party because LA collector acquires the property on behalf of this other.
On receipt of requisition from such and such.
Only.
So it is a acquisition under Section Act 1.
He is not made party there. I think he is to be.
There you take instruction.
She will serve on the
It is
Indian
the
Corporation.
it is the always quote here.
Lordship, the prayer, Lordship always has the power to move. Lordship will kindly just see that document why I am before my lords. A hearing has been conducted.
I have a power.
Lordship,
So why I shall you exercise you?
Lordship will kindly.
It is a charity.
No, Lordship, it's not charity, but Lordship.
Power is many things.
Lordship is sitting for
Power
equity.
of charity, that is
My lords, one
there
person,
must be justification.
Lordship, one person since 2018.
Post office, you are to throw a petition, no pair, nothing. It is a pair. It is a pair, a treated degree. Which degree? Not mentioned. I am reading. A writ of mandamus in the nature of mandamus declaring a degree of a learned civil judge. No mentioning, nothing. Which degree? Passed by which court? In which suit? If not appealed against at a finality, and such declares absolute title in the land to the parties as mentioned therein.
Lordship will not.
Have you understood anything?
Lordship,
Which degree? Which court passed? Have you got the writ petition?
Yes, yes.
Huh?
Yes.
Hearing this pair, whether any court has got any tenacity to enter into the merit. It is the pair.
Lordship will kindly just appreciate the situation, my lords.
I am to issue writ of mandamus, Constitutional Court, prerogative writ, based on this pair.
Lordship will kindly not take me amiss, my lords. It is what it is. I cannot.
Dismissed since the pair.
Lordship will not take me amiss, my lords.
My lords, liberty is granted to file a press.
My lords will kindly, Lordship, just.
No
Lordship will just
kindness.
appreciate,
No
my lords.
kindness. This is court of
Lordship
law.
will just kindly appreciate
court
the
of
fate
law.
of the litigant, my lords. So will just kindly appreciate the fate of the litigant.
Litigant has done the wrong in making a choice of such draftsman for him.
Lordship will not put the litigant at cost, my lords. Lordship will just kindly not put the litigant at cost. Lordship will not take me amiss. Lordship, the only innocuous thing I was requesting, my lords, I'll serve a notice again on the internal corporation. If required, my lords, is that they've done a hearing, they just tell me what is the outcome of it. Lordship will just kindly appreciate.
Go out of list, a petitioner is directed to take appropriate steps. Okay, liberty to mention.
Lordship will just also say we'll serve a notice on the internal corporation. Lordship will just mention it with Lordship's order. I'll serve another notice because we served it.
You even is not aware of the fact under which act land was acquired.
My lords, may I
And
just?
who is the competent?
I have the act, my lords. I can place the act, my lords. I'm
say,
carrying the act.
don't open the brief. You say under which act the land was acquired.
Lordship, I receive a notice from the interior under the
Under
Petroleum
which
and
section? Under which section?
under the Petroleum and Minerals Pipeline Act, my lords.
So whether this act has a power, has empowered any authority to acquire the land.
Lordship, this act authorizes
Appear
the authority. Lordship,
this the court, go through the brief,
Lordship,
take in proper information so that you can assist.
I can only assist, my lords.
The court's impression would be otherwise.
I can just assist, my lords.
The last and first matter.
Absolutely not, my lords. I can assist my lords on this, Lordship. The act empowers.
Again.
The act empowers the competent authority to look into and conduct a hearing and then pass an order of compensation.
In habit of making argument.
No, Lordship, I am Lordship taking me amiss.
You tell you are creating irritation in the world. You tell under which act the land was. You want compensation. You want a writ of mandamus. You don't. Have you drafted this petition? You want you are before a constitutional court.
My lord.
You want a writ of mandamus by which one particular officer will be commanded to do something.
Lordship.
Huh?
Lordship.
You don't know and to pay compensation.
Lordship.
But you don't know under which act the land was acquired. You are unable to assist the court under which act the land was acquired. Whether the pipeline has empowered. You don't know the answer. Whether Act 1 was invoked, you don't answer. Whether Act 2013 was invoked, no answer.
So the compensation would come as per this act of the pipeline and minerals. So over there, Lordship, the section 10 says, I have.
Find out whether this act has empowered any authority to acquire the land or not. National Highway Act has empowered the highway authorities. Now, whether this act has empowered anyone,
Lordship.
Don't
May I-
appear casually before the court.
May I place this? My only thing is I don't have another copy. There's only one copy, which the advocate record has bought. Otherwise, I would have handed it over to my lords and been able to assist my lords better to the best.
You have not read at all. It is not the time that court will allow you to take preparation before this
No,
court.
my lords,
The matter you will go on. Okay, hence appropriate order is let the matter go out of list, liberty to mention, you take appropriate steps. Okay, next.
Lordship, great. Item number 30.
Lordship, item number 30, I am appearing for the respondent number 1, Lordship.
Don't appear.
My lord, I appear on
I have
behalf of
seen you to make good submission. I have heard your submission, your argument. I was impressed. But today you have not read the brief. You have not read the relevant law. Nothing. Even you have not seen the prayer.
So the prayers I knew was, but that is what it was.
You should have made an application.
Couldn't have bettered what had come to me.
Allow me to amend the prayer portion.
I should have, man.
There is a judgment. I cannot give anything beyond the prayer unless it is prayed for. Why I shall give? Why it is as and when mayor asking, I shall go on molding relief.
No, man. I understand what's troubling my lords.
It will be giving indulgence to a lackadaisical approaching the court. The litigant who is diligently pursue their remedy in the court, the court is for that, for them.
Sometimes, Lordship, the brief comes like that. We could not come after.
Calendar you have to say.
Absolutely, Lordship.
I shall not go with the
We shall learn. That's how I learned from my lords. I'm grateful, my lords.
I shall not go.
I'm grateful, my lords.
You amend this prayer portion, then I shall appear. Otherwise, I shall not appear.
Will it be my lord's pleasure to give me that leave to amend? I'll then file the appropriate application. Lordship's passed an order.
I have given liberty.
I will take
whatever you do.
I will. Grateful.
Next.
Lordship, I am appearing for respondent number 1, Lordship, in this matter.
My lord, I
Item
appear
number
on behalf of
30.
IBPS, my lord. 30, my lord.
30.
My lord, I was praying for one day accommodation, my lord, being late by Mr. I, my lord.
Okay, bottom of
Lordship, may I
My lord,
submit?
my lord,
Lordship,
may
may
I
I
retain
submit
his
one
position,
thing,
my lord?
Lordship? Lordship, may I submit, Lordship? Lordship, there is a central government notification, Lordship, by which 3 banks, including the respondent number 1, has been amalgamated into West Bengal Grameen Bank, Lordship, with effect from 1st of May 2025, Lordship.
Rural bank has amalgamated.
Yes, Lordship. Lordship kindly allows me to file one affidavit to the effect annexing the notification, Lordship. Because then the cost title has to be changed, Lordship, also by the petitioner.
You are for respondent number 1.
1, Lordship, Uttarbango Kshetriya Gramin Bank.
Ms. Sengupta, learned advocate, repenting the respondent number 1, prays for leave to file affidavit in opposition to bring subsequent development to the effect that during pendency of this petition, ঠিক আছে the উত্তরবঙ্গ গ্রামীণ ব্যাংক বঙ্গীয় গ্রামীণ উত্তরবঙ্গ গ্রামীণ ব্যাংক
Uttarbango Kshetriya Gramin Bank.
ক্ষেত্রীয় গ্রামীণ ব্যাংক has merged with West Bengal পশ্চিমবঙ্গ
Merged into West Bengal Gramin Bank. A new bank has formed, merging 3 Gramin banks.
New bank has formed new bank, namely,
Lordship, the 3 banks are, Lordship, Bongio Gramin Bikash Bank, Paschim Bongo Gramin Bank, and Uttarbango Kshetriya Gramin Bank. These 3 banks merged into West Bengal Gramin Bank.
West Bengal Gramin Bank and the Uttarbango Kshetriya Bank, along with some other financial banks, have merged with this bank. He placed for leave to file affidavit in position to bring the notification by which those banks are merged on record. So, leave is granted. Let such affidavit be filed within a period of 1 week.
Lordship, 2 weeks, Lordship. Kindly, Lordship, 2 weeks.
You are not to respond to that. Let the matter appear in the list 2 exchange. Next.
Lordship, grateful, Lordship, grateful.
My lord, was directed on 26th. My lord, I'm
Yes, next 31.
31, my lord, I was praying for one day's accommodation in this mailbox.
Okay, bottom.
My lord, kindly, my lord, retains his positions, my lord.
Bottom, next, bottom.
32.
32.
32, your lordship, I'm for the petitioner.
Yes.
Well, I'm for the status funds, my lord.
Your lordship, the petitioner on March 5th, 1991, executed a sale deed. Your lordship, before
To hand over registered deed of sale to your petitioner.
Actually, your lordship, the stamp papers of 500, 100 and 100 stamp paper, they were found to be not genuine. So, your lordship, I prayed that I will replace those stamp paper, liberty may be given. Now, your lordship, thereafter, I preferred one writ petition. And that writ petition...
Before whom you place this stamp paper? Submitted
Before the
stamp
register.
paper for whom? Register assurance, register Mednipur.
Mednipur. Now, your lordship...
Forged.
Not forged, they were found to be not genuine. Now, your...
Far from you got it.
Yes, your lordship.
Far from you got it.
That, your lordship, maybe the clerk...
Let an inquiry be held against you.
No, your lordship, I preferred a writ petition thereafter. In that writ petition, or by order dated March 17, 2008, I was allowed to show that my prayer may be considered. Now, in that writ petition, I, along with my nephew, both were the writ petitioner. Now, my nephew had done that thing and he got the deed back. But due to some problem, I could not approach.
Where is the
It is a
order of that writ petition?
Your lordship.
You have suppressed the fact.
No, your lordship, I'm not suppressed.
So you have not annexed the same?
Yes, your lordship, page number 15.
Page number?
15.
Yes.
Your lordship, having heard the learned counsel for the parties and having regard to the nature of controversy raised in the petition, this court is of the opinion...
I do not know when this order was passed, my lord. No date mentioned.
What is the date?
Your lordship...
Where is the copy of the order? You have typed something.
Yes, my lord.
Whether it is also ingenuine?
No, your lordship. I've stated in my writ petition.
My lord,
because
the
of
writ
March
petition
17,
is take
2008.
Ansarali. His Ansarali is not the purchaser, my lord. Purchaser is another.
No, I have
Mohammad Mohila Khatun.
two petitioners. The petitioner number 1, the petitioner herein, along with her nephew, two deeds were executed, and both of them filed one same writ petition. And my nephew got the
Mohila
writ petition
Khatun is
as
the
per
only purchaser.
the writ petition.
Where from you got it in genuine stamp paper?
That, your lordship.
What is your source?
From the clerk, your lordship.
Clerk?
Clerk, at that point of time in March.
Okay, so
1991.
let an inquiry be held against you.
Yes.
Because you want refund back.
No, I'm not refunding. I was replacing back, your lordship.
There may be possibility for its reuse.
No, that can be cancelled by the, that is also already typed therein, and that will be cancelled.
You conduct an inquiry.
Yes, my lord.
Refund, you forget about the refund.
Yes, my lord. Kindly pass order, my lord. Kindly.
Forget about whether ingenuine in a office, government office, you will submit ingenuine stamp paper, then government will will return you back so that he can reuse it another government office.
Yes. Kindly pass order,
That
my
cannot
lord.
be used. That is written
The
over
whole
the
inquiry.
My lord, yes, my lord. Kindly pass order.
Inquiry.
Kindly pass appropriate order.
Who got the ingenuine stamp paper?
Your lordship
Now,
can pass order, my
as
lord.
per the order of the writ petition, my nephew got the that deed back. On the basis of the order of the writ petition, that to consider
Writ petition, you also, it is a
no date, no cause of
date,
action.
nothing.
the type
The
copy,
order.
your lordship, I can produce the certified copy of that writ petition.
এই ডেট কবেকার অর্ডার এটা ডেটটা তো নেই
আছে writ petition
এখানে তো নেই বাঁদিকে তার ডেট থাকার কথা
2008 on March 17, 2008, your lordship.
It is also, there is something.
No, your lordship.
এই পেজে তো ডেট নেই
This is the copy, your lordship, of the writ
Your
petition.
name is Aditya Shankar Roy.
Yes, this is the copy, certified copy.
দেখে আমাকে একটা
হ্যান্ড ওভার করেছি
একটা এক্সট্রা কপি তো আছে
এক্সট্রা
So you made an application court disposed of by directing, they will consider that. They have not passed any reason order.
they are passed and my
What is
nephew
that reason order?
that reason I could not apply, your lordship. That is my failure. My nephew applied before the register, he got the deed back, and due to some problem I could not apply, and the time period limit was for 4 months. I missed that opportunity. Thereafter they told me to get a fresh order. Thereafter I filed this writ petition.
I shall order for inquiry wherefrom you have got the engineering stamp paper. That would be appropriate for you, for all of us.
But your lordship, the
Telgi
deed
case,
was
what?
of the deed was of 1991 only, your lordship.
Eh?
The deed was of 1991.
Well, why he waited for a long time? Well,
So what? That is ingenuine. So why,
That was
what you
ingenuine.
will do with it? It is as a cancel. If you want to transfer, in the meantime, you purchase fresh stamp paper and get the deed registered.
That was my prayer that let me
It is your
replace it.
intention to get that stamp paper, which is according to you engineering.
Not according to me, according to the registrar. After they have registered, and when I prayed for to give the copy
Okay,
of
so
the,
register has concluded that this stamp
these
paper
are
is
ingenuine.
genuine.
So my prayer is I will
Now,
replace.
why you are interested to get back those ingenuine stamp paper?
No, I am praying for replacing them with the
And
genuine.
why it would be handed over to you? You forget about those stamp paper. It has been lost. It would be destroyed.
Yes, it will be destroyed. But
Ah.
let
It
me.
would be destroyed. That direction shall be given.
It should be destroyed, your lordship. But the thing is, I may be allowed to replace them.
You prepare a fresh deed and get it registered. The present petition has been preferred, seeking a direction upon the Okay, bottom.
Lordship, I'm for the petitioner, Lordship.
Yes,
The respondent, Mr. Bari was.
you are ready.
Mr. Shamimul Bari is appearing. Mr. Shamimul Bari is appearing on behalf of the petitioner. He was here, Lordship, as the opposite sides informed us that they'll pray for adjournment. That is why he left the court.
Doctors required when operation will be done. Doctor is present, roaming around the hospital. When the patient is placed on the operation table, then doctor is there. No. It's not
Well,
fair.
then
Okay.
I'm praying for a short.
Okay, you get your chance later on. Bottom next.
34.
Huh?
I'm for the petitioner.
Yes, please.
For the state.
I am appearing for the respondent, Midnapur municipality.
Item 34.
My lord, 34.
Yes.
What is the matter is post facto approval of post cashier and pensions. After retirement. No, I'm submitting another thing, the supplementary affidavit for more information got after submission of the writ petition, after filing the writ petition.
Have you given
I have
copy?
given the copies.
The court granted you leave to file such supplementary affidavit.
No, my lord, no.
No.
My lord, before my learned friend starts, my lord, may I, my lord, submit one thing, my lord. Previously, matter was taken up by Honorable Justice Amrita Sinha and direction was made for exchange of affidavits. But thing is that after this order, my learned friend who is appearing for the petitioner, he got the brief. Actually, this writ petition was filed by another advocate. Subsequently, transferred brief, he is appearing. My lord, he has prepared this supplementary affidavit and he has also filed one application. But wherefrom, my lord, I have come to know law has been changed and some amendment is there. So, my lord, another leave is to be granted, my lord. Otherwise, my lord, neither state government, neither my lord, we cannot file affidavit. But without file,
My lord, the case is the petitioner is there. He wants post facto approval of the promotional post after his retirement.
no,
Whether
not that.
was
This petition
applied
was
before
filed on
retirement.
14th June
After that,
2022.
he has retired, and then I filed a can to inform the court that he has been already retired. Superannuation of his pension others is done as per previous post, that is licensed inspector, and he was promoted by the order of
coordinate bench directed them, coordinate bench observed that this matter should be decided upon affidavit.
Upon affidavit.
Upon affidavit. So let them come at a comprehensive affidavit.
Lordship, please consider that he is already retired. He is not getting any pension as it is sub judice. As per their online application of pension and gratuity, etc., he is not getting anything, and he is suffering from hardship. And that is why I am telling you that actually the fact is, as per rule, the director of local bodies did not consider the rule of West Bengal service.
The supplementary affidavit filed on behalf of the petitioner is taken on record. আর কিছু হবে
আপনার এভারমেন্ট তো তাই বলছে।
আর কিছু হবে হ্যাঁ 35 টাকা 35 petition
My lord, I am for the response.
আর সকালবেলা শুধু আমি হ্যাঁ
We have already filed the affidavit. Affidavit is taken out of record.
bottom of the list আর কি
Bottom of the list.
ও কত ম্যাটার
এই এখন দিয়ে দেবে না?
Mr. Roy, what is the matter about?
This is, my lord, lordship has heard before your lordship went before the circuit. This is that matter, my lord, where the transfer of the school teacher is involved.
Oh.
There, my lord, it is the application made by the school teacher for transfer on the medical ground. And my lord, my contention before your lordship, the rules say that the school is not forwarding my application after getting my medical documents verified by the doctor concerned. So my lord, the rule says that the school doesn't have the authority to withhold or reject the application for transfer made on the medical ground. So my respectful submission before your lordship, even in spite of that, the school has been withholding my application years. But I will be praying before your lordship's direction so that the school gets my medical document verified by the CMOH or BMOH concerned, and thereafter the necessary steps will be followed accordingly. And if my application deserves to be, my lord, entertained on the basis of the rule, on the basis of the opinion of the CMOH, in that event, my lord, it has to be forwarded.
Who is for the school authority? So you take opinion from the CMOH,
Kindly have
and if you find justification in his pair, then forward, otherwise refuse.
Kindly have a look to the order dated 6th of August 2024, passed on this matter. The institution has only 3 teachers, including this present one, having 4 units, class 5 to 8. Now, already if he left this institution, then we would have only 2 to manage 4 units. So in every classes, or either class 5 and 6 and 7 and 8, those are to be accommodated in a single classroom. That's the situation which we are facing.
But this cannot be taken to be a ground, my lord. I tell your lordship, because here
The school is for the students. In the interest
there.
of students, that should be taken care of.
Absolutely there.
But if someone is sent there, well, we have no objection. If someone is sent as a reliever, we don't have any objection. But we want to save this institution, nothing else. By 2 teachers, we cannot run the institution of a 4 units. That's my submission.
Only 2 teachers, and only now
Only
3
3 teachers, including him. Now, if he leaves,
Enter school.
How many students are there? The sanction strength is 3, my lord.
Sanction strength
is 3. It is a junior high school new setup.
Junior high school 3.
Yes, junior high school new setup.
Then can't be.
Sanction strength is 3. There cannot be more than 3.
Strength of student?
It is my instruction 25. My learned senior, my lord, will be saying what is that?
But this is a new session, my lord, we have to take instruction.
Then
can I keep this matter on any day?
So
Let me take the instruction.
My lord, we make our submission. We'll have to, my lord, be in the 4 corners of the statute.
No.
We cannot say something, my lord, which the statute does not permit.
No.
Subject to lordship's correction. The statute says that yes, if in a particular school there is 1 teacher or no teacher, in this particular case, he is single teacher in this particular subject, there is no other teacher, yes, he should not be transferred. The statute puts this embargo, undoubtedly, I admit this. But at the same time, the provision just below that, I have annexed, just below that specifically says that this embargo will not be applicable in the case where the application has been made on special grounds. 4 special grounds are there: medical, divorce, disability, and another. I forgot that. So there are 4 special grounds. If someone makes this application on special ground, then there is a procedure left. And that embargo will not be applicable if the application is made on special ground. But this has been held by this honorable court, by the honorable division bench time and again, where my learned senior friend, my lord, has been part in several matters. My learned senior friend knows better than anybody else. So this point cannot be taken in rejecting or, my lord, refusing my prayer for transfer. Now this is one. And with respect to the other, that the other teachers and all this, my lord, this is a new setup, junior high school. The sanction strength is this. If we take this submission of my learned senior here,
then in that event, this provision of transfer will not be applicable in my case ever after.
Should not be.
But I tell your lordship, if I just take your, if my lord senior friend takes time in that event, I'll not trouble your lordship. I'll only take your lordship to the rule once and nothing else, which I've annexed.
Okay, not this week. You take
Yes,
instruction in this week. Huh?
In the meantime, my lord, I must request my learned friend that this matter is of 2022, I believe.
Yes.
So all the, my lord, his illness, the illness of this petitioner relates back to 2022. I don't know
Yes,
whether those subsist till date or not.
So that is exactly why I pray that I should be examined by the CMO is concerned.
We can do one thing. Keep this matter pending.
That is exactly what I pray.
Keep this matter pending. Fresh application করবে কোথায়? Portal কি open হয়েছে?
Yes. Yes, yes.
They can file an application after.
Why would I?
That has to be forwarded by the school authority.
Now, whether earlier application has been rejected?
Yes.
Rejected.
That was not forwarded by us.
Not forwarded by the school.
That means rejected.
That is my prayer. That is my grievance. Why would I make a new application?
The appropriate authority to consider the application for transfer. But in the when an application is filed on medical ground, take the views of the BUME, got medical records. And if the BUME report suggests for transfer, then the school authority will issue NOC.
Yes.
And follow.
Yes, Malon. But I do appreciate that. Kindly have a look to the, yes, kindly have a look 6th August 2024 order, the second page, internal page 2, second paragraph. In addition thereto, it has been submitted that the school has obtained medical opinion from Block Medical Officer of Health, Beldanga 2, Shaktipur BPHC Murshidabad, which doesn't justify transfer. Well, the page, internal page 2 of order dated, order passed in this writ petition, Malon.
As per application form.
The order passed in this writ petition.
Oh,
6th August 2024.
yes, yes.
Now kindly come to the internal page 2. Second paragraph starts with in addition thereto, it has been submitted that the school has obtained medical opinion from Block Medical Officer of Health, Beldanga 2, Shaktipur BPHC Murshidabad, which doesn't justify transfer of the petitioner. However, the said certificate of the concerned BUMH dated so and so is disputed by the learned advocate for the representing the petitioner. So just now, which has been submitted by my learned friend, Mr. Roy, that we have to obtain from BUMH, that was obtained, and that is not in favor of the petitioner.
Where is that? Nowadays, we are relying on the submission of the learned lawyers. Till today, there has been a direction
The court coordinate bench has recorded that.
Yes, this is why direction for affidavit has been given. Did not give. Why are they shying away?
We can do one thing. And the next day, we shall hand over this to them. No issue.
Why they did not do it for the last 2 years? I am putting.
He knows everything.
They will be submitting from the bar.
Indicate the decision taken by the managing committee regards to the forwarding the transfer application.
Yes, that we can. That we can.
How about the said certificate of the concerned BMO dated August 8, 2022 is disputed by the learned advocate?
Yes.
Advocate for the petitioner.
That the advocate of the petitioner.
Yes.
Yes.
So that certificate whether was brought on record?
No, that cannot be on record. That is lying with the school authority.
Yes.
No, did they use any affidavit to that effect? Because there was a direction for filing the affidavit.
PCOD syndrome for last 1 year. She need proper treatment, require further gynecological investigation. PCOD syndrome is a major serious gynecological disorder, so it will not be hamper her husband. Regular work as a teacher, it will not hamper further conception with her wife or the second child if wanted.
Yes. So how is it against me? I don't follow, my lord. They will not use any opposition. They will not, my lord, comply with the rule. They will be submitting for the bar. So
you are attending the school?
My lord, I have been attending the school, my lord. I tell your lordship, my residence, my lord, is Amdanga, North 24 Parganas, and my lord, the school is Beldanga East, Murshidabad.
She is residing there. She is staying there.
Murshidabad. So, my lord, I will be only requesting your lordship.
This certificate is not clear as to whether you will be able to attend the school
Exactly
regularly.
the point. Exactly the point.
Since you are suffering such and such. Suffering
Exactly the
from
point.
Sanasana.
My lord, the provision says BMOH, thereafter it has to be verified by the CMOH. In all the matters, the cases of these incumbents are related to the CMOH. Let me be checked up in the CMOH. If I am not found eligible, my case to be dismissed, my transfer application to be dismissed. That is exactly what I pray. Does anything by the rule, if my land senior friend shows a single scrap of the rule which permits them to withhold my application, in that event, my lord, I'll be out of this court. They do not have anything to that effect.
Where
They
is the
will not-
CMOH? That the CMOH is the appropriate authority,
not-
not
My lord,
BMOH.
if the rule, my lord, that I've annexed, if I request your lordship, my lord, the rule is,
Page.
my lord, the rule starts from page number 26. I'll request your lordship, my lord.
Applicant wants to back.
I will request your lordship, my lord, to see, my lord, which 6 now? No, no problem.
Since the state
But,
authority is before your lordship,
That notification, it is
page-
27.
My lord, page number 30.
That there was another notification.
My lord, page number 35, my lord, says, that is the amended rule right now.
Yes.
দরকার নেই,
Yes.
দরকার নেই।
So here your lordship kindly sees. Hey, Sunita?
উজ্জ্বল পেজ নাম্বারটা একটু বলো।
Rule 6. কোনটা বলো?
My lord, may I suggest?
Kind of
Hey,
ask for
you-
root of that.
You
So six, my lord, six. That is it.
And if the report of the COE suggests.
The district, the matter has not been sent to district.
That is the mistake.
School as yet.
That is the mistake that they cannot.
Yes. School authority. Yes.
The rule permits that there has, opinion has to be sought for from the concerned DOH or COE. That has to be okay.
That is exactly what I'm praying. Lordship sees page number 36 of my writ petition. It is to six, no?
Yes.
My lord, page number 36, my lord, will be the my lord rule. Here I'll be referring your lordship, clause 3. No, first my lord sees the embargo and this thing 61 C sees my lord first.
Yes.
Consider the number subject or the strength if the resultant vacancy of the regular school is 0 or not commensurate to the rule strength. The authority of the SMC shall not forward the application. This is the embargo. The next my lord sees D, another embargo of 10%. Then comes to E. Dispense with the provision of C and D of this sub rule for application made on ground mentioned in A to D. So A, your lordship would see above or on the previous page, the last line, which is medical ground. So my application is on the medical ground. So in my case, B, C and D will be dispensed with. Now my lord comes down, what will be happening in those cases? In the medical grounds. Now my lord kindly sees F. Cause to examine the applicant. Has your lordship got this? F. Cause to examine the applicant by the doctor of this SMC, School Managing Committee. In case of transfer application made on medical ground mentioned in clause such A of rule 4 and and must indicate disease of the applicant which has been done. Must indicate the disease of the applicant which caused the serious problem in attending the school. That is done. Then comes down. Issue no objection
Your
certificate.
syndrome, considering your syndrome, BMH opine that no problem, you will be able to conceive and everything all okay.
It is not about conceiving, my lord. It is about the gynecological problem which is troubling me to trouble this part of the school. This is the intention of the legislature, man. It is not about conceiving. So, my lord, my respectful submission before your lordship, after this BMOH, the school has to issue the NOC. And then, my lord, comes down.
Which
3B.
Which is
3B. My lord, 3 at the bottom, page number 36.
Yes.
Page number 36, bottom, my lord, clause 3, lordship says. District inspector concerned upon receipt of the NOC, verify the service record. B, take the view of CMOH of the transfer application related to the medical ground reported by the doctor of the SMC.
When the matter has been referred to the district
Yes.
district
Yes.
inspector of school.
Yes. So I filed this writ petition.
So the, according to you, school authority has got no authority. He will just,
Doesn't.
like post office,
Doesn't.
like post office, he will send.
Absolutely. Doesn't.
Application has been posted.
Medical note
he will
application,
take
get
it out and send it to the RDR.
as a post office, subject to correction.
As a post office.
As a post office. Because this is what has fallen from your lord, from this honorable court, the honorable division bench, from 2015 onwards. I have all these judgments, my lord, with me. That
The school authority is also post office, only post office.
Dearth of school
Only
teacher-
forwarding authority.
Yes, here the intention of the legislature is that the wording of the legislature is that, because I tell your lordship what happens in the school. Well, at school there is possibility of different kinds of problem and malpractices as well. So the legislature thought it expedient to get this matter verified by the doctors. If the doctors say that he is fine, then I do not get the transfer. If the doctors say that he is not fine, in that event, my application has to be forwarded. Or in this case of this SMC, lordship sees what is the doctor required to be said, that what is the name of the disease of the school. This BMOH says this is the name of the disease of the school. Then it has to be verified by the CMOH concerned. If the CMOH thinks that I am not eligible for transfer, or my argument is not even completed. My argument is not even completed.
First comes to F, which says first to the school authority, also to examine the applicant by the doctor of the SMC in case of transfer application made on medical grounds mentioned in clause A of the report, and must indicate the disease of the applicant, which cause serious problem in attending the school. After the school authority will take opinion of the doctor. If in the event the concerned doctor says that the applicant is suffering from a kind of disease for which he can get transfer, then only the school authority will issue NOC.
Absolutely.
The application.
Absolutely. Absolutely.
Inspector of school will forward the.
Absolutely.
That's why at the very first instance I have.
It is a double check. Check. Yes.
Yes.
By the CMH also.
Yes.
So I'm not acting.
Yes.
First instance I have submitted. Here designate this repetition schedule for the 3 weeks. Now it shows the portal. He has made an online application that is also closed. Let my learned friends time, but it will take a time. Make an application within a period of 1 week. The school authority will get it cross-checked from the concerned BMOH in case his physical condition is such that she deserves a transfer, where his application or the entire process will be done offline.
But this is beyond the law which is submitted now. This is beyond the law. With deepest of respect, it is beyond the law.
This application.
The application is pending at the behest of the school.
Kindly have a look, page 50.
That
What is
means,
her?
man,
Kindly
that
have a
means
look, page
they have this.
We are fighting for her causes. Well, page 50.
It is a matter of 2020.
Yes.
The
Page 50, one
physical
space 50.
condition of 2022 cannot be same as in 2025.
Absolutely, my lord.
Either it will be
This is why
deteriorated
my
or
lord,
you,
why, my lord,
Suffering from PCOD syndrome.
you made application, face application with current medical report and document.
my lord, that will be, my lord, putting me back. This is exactly why, my lord, learned.
But I appeal to
School
your lordship
Commission
to kindly have a
have
look, page
submitted this.
51, my lord.
That this is
Of
what
their
is-
writ petition.
Yes, kindly see
Page 50.
Yes.
That's the certificate given by the BMOH that was tagged by them
Yes.
dated 19th of July 2022. What are the causes?
Yes.
It says this is to certify that so-and-so, wife from so-and-so, that the address is there, has been suffering PCOD syndrome for last 1 year and regularly
Irregular
menstrual
menstrual
cycle disorder. Now, so she needs
is called
proper,
gynecological
so
disorder.
she needs proper treatment, and timely care from the family members. I don't follow, my lord. Why it has been saying this? She has been suffering to attend any duty. It causes.
Let
I couldn't
this
follow.
be recorded, my lord.
I couldn't
What has
follow.
fallen from my lord, but my lord is senior.
PCOD is a
It is
PCOD is
not
common thing.
BMOH.
It's a BMH, my lord.
It is OPD advice.
My lord, now, as
Thereafter,
per
in the month of August, you, Mr. Roy, court is giving you liberty. You file a fresh application offline. offline. Now Utsosri portal is
Lordship,
also
Lordship, kindly do not do
not
this. My lord,
functional.
I'm not praying for that liberty. If your lordship dismisses my case, my lord, kindly dismiss. I will not pray for this liberty. Because I tell your lordship, because as per the rule, the PMOH has opined that specifically named the disease which I am suffering. After that, the school is under obligation of the rule to provide NOC and forward it to the district inspector.
If it says
Since they did not,
he has been suffering,
then I have to.
So in that circumstances, I am to invite you file affidavit in opposition.
My lord, that has been done back in 2022.
Yes.
That has been done, my lord. I should not be bent, my lord.
Preemptively.
yes. Within 7
That has
days,
been
10
done.
days, my wish.
That has been done.
7 days.
Within 7 days, Usha. Fix the matter.
Okay, acha.
By using an affidavit,
Record
I do not know how they
reveals-
can change the law.
Record reveals that a coordinate bench of this court, in its order dated 6 August 2024,
Since my learned friend Mr. Roy is appearing for the commission, he's present before the court. Let his name be regularized. Otherwise, I will once again put to serve on this commission.
আচ্ছা আমি
to 50 by the, I am praying by the to be fixed at 2 p.m. by 2.
No, not in this way. It would be serial. It would be called serial.
Evening session,
No, it would be called serial.